Share, IA next. Page. Here's a detailed study note based on your outline. Underscore. Chapter 1, The Notion of Contract. 1.1 The Notion of Contract. 1.1 Contract as an agreement intended to create enforceable obligations. A contract is a legally binding agreement between two or more parties that creates enforceable obligations. Essential elements include offer, acceptance, intention to create legal relations, and consideration, or causa in civil law traditions. 1.1 Two legally binding agreements that are not contracts. Some agreements are legally binding but do not qualify as contracts. Family agreements, for example, marriage settlements, trusts and wills, legal instruments rather than contracts. Public law obligations, for example, tax obligations, licenses. 1.1.3 Legally binding agreements that are more than just contracts. Some agreements contain contractual elements but also involve public policy considerations or statutory obligations. Employment contracts, regulated by labor law. Consumer contracts, governed by the Consumer Protection Act 68 of 2008. Administrative contracts, between individuals and government entities. 1.1.4 Definition of contract. A contract is defined as an agreement entered into voluntarily, between parties with contractual capacity, with the intention of creating legal obligations, and supported by valid causa or consideration, depending on legal system. Underscore. 1.2 Requirements for a valid contract. A valid contract must meet the following requirements. 1. Consensus, agreement, mutual intention to be legally bound. 2. Capacity, parties must have the legal ability to contract. 3. Legality, the contract's purpose must be lawful. 4. Formalities, certain contracts require specific formalities, for example, written contracts for land sales. 5. Possibility, the contract's obligations must be objectively possible to perform. Underscore. 1.3 The nature of contract. Contracts regulate voluntary obligations arising from agreements. The principle of pacta sunt servanda, agreements must be honored, underpins contractual enforcement. Underscore. 1.4 Contract and the law of obligations. 1.4.1 The concept of obligation. An obligation is a legal bond requiring a party to perform a duty. Contract law is part of the broader law of obligations, alongside delict, tort, and unjustified enrichment. 1.4 Contract and delict. Contract, based on agreement between parties. Delict, tort, based on wrongful conduct causing harm, independent of agreement, for example, negligence claims. 1.4.3 Contract and enrichment. Unjustified enrichment occurs when one party benefits at another's expense without legal justification. Contracts can intersect with enrichment law, for example, when a contract is void, but performance has been made. Underscore. 1.5 Contract and the law of property. Contracts transfer ownership, possession, or limited real rights. Examples: sale, lease, mortgage, pledge agreements. Property law governs real rights, while contract law governs personal rights, obligations between parties. Underscore. 1.6 The development of the modern notion of contract. 1.6.1 Roman law. Contracts classified into 4 types. 1. Verbal contracts, stipulatio. 2. Literal contracts, written formalities. 3. Real contracts, transfer of an object. 4. Consensual contracts, based on agreement, for example, sale, lease, partnership, mandate. 1.6 To Roman Dutch law. Incorporated Roman law but emphasized freedom of contract and good faith in contractual dealings. Recognized pacta sunt servanda, but also allowed certain exceptions, for example, contracts violating public policy. 1.6.3 Causa and consideration, a celebrated dispute. Roman Dutch law, A contract must have a justa causa, a lawful cause or reason. Common law, English law, a contract requires consideration, something of value exchanged. The causa consideration debate affects whether gratuitous promises are enforceable. _1.7 The impact of the Constitution. Section 39(2) of the Constitution, contracts must align with constitutional values such as dignity, equality, and freedom. Courts may invalidate contracts that violate constitutional principles, for example, unfair contractual terms, discrimination. Public policy and Ubuntu increasingly influence contract enforcement. _1.8 The basis of contract. 1.8.1 Introduction. Contractual obligations arise from consent between parties. 1.8.2 Actual subjective agreement, consensus, true intention of the parties determines contractual validity. Mutual assent is required. 1.8.3 Apparent or objective agreement. Even if one party lacks subjective intent, objective factors, for example, conduct, words may indicate an agreement. 1.8.4 Theories of contract. 1. Will theory. Contracts are based on the actual intention of the parties. 2. Reliance theory. A party is bound if another party reasonably relied on their promise. 3. Objective theory. Contracts are interpreted based on external conduct, not internal intent. 1.8.5 Approach to contract, subjective or objective. Modern law balances subjective and objective approaches. Courts examine parties' intent and reasonable expectations. 1.8.6 Dual basis of contract in modern law. Combination of subjective consent and objective reliance. Courts consider public policy and fairness when interpreting contracts. 1.8.7 Proving the existence of a contract. Written contracts, if required by law, for example, land transactions. Oral evidence, if permitted. Conduct of parties indicating agreement. 1.9 Cornerstones of contract. 1.9.1 The goals of contract law. Promote certainty, fairness, and economic efficiency. Facilitate voluntary exchange. 1.9 2 Competing values in the law of contract. Freedom of contract versus fairness and public policy. Balancing individual autonomy and consumer protection. 1.9.3 Freedom and sanctity of contract. Freedom of contract. Parties may negotiate their terms. Sanctity of contract. Agreements must be honored unless invalidated by law, public policy, or constitutional principles. 1.9.4 Good faith, equity, and public policy in contract. Good faith, implied duty of honesty and fairness. Equity, courts may intervene if strict enforcement leads to unfair outcomes. Public policy, contracts violating constitutional values, morality, or legality are unenforceable. 1.10 The Consumer Protection Act 68 of 2008, CPA, aims to protect consumers against unfair contract terms. Key provisions. Right to fair and honest dealing, prohibits misleading representations. Right to fair, just, and reasonable terms, prohibits excessively one-sided contracts. Right to cancel fixed-term contracts under certain conditions. Courts may invalidate unfair contract terms under the CPA. This summary covers key principles while emphasizing legislation and case law relevance. Let me know if you need case examples or further elaboration on any section. Next page. Here's a structured summary of the provided text. 1.1 The notion of contract. Definition and differentiation from other agreements. Not all agreements are contracts. Contracts require a legal intention. 1.1 Contract as an agreement intended to create enforceable obligations. A contract is an agreement between two or more parties that is legally binding. Examples of non-binding agreements. Social agreements, for example, agreeing to play tennis. Domestic arrangements, for example, a spouse agreeing to wash dishes. Jokes or staged agreements, for example, actors signing on stage. Key legal requirement. Animus contrahendi, serious intention to create legal obligations. Examples of non-binding agreements. Gentlemen's agreements, binding in honor, not in law. Letters of intent or agreement subject to contract. If a party appears to have contractual intent but does not, the law may still enforce the contract based on the reasonable belief of the other party. 1.1. Two legally binding agreements that are not contracts. Some agreements create binding legal effects but are not contracts. 3 types of legally binding agreements. 1. Obligationary agreements create obligations, for example, contracts like sale and lease. 2. Absolving agreements extinguish obligations, for example, cancellation of a contract. 3. Real transfer agreements transfer rights, for example, traditio cession. Example: sale contract, seller S and purchaser P agree to a sale. Transfer of ownership, traditio involves delivery plus intent to transfer/acquire ownership. Cession, transfer of a right, for example, a sells debt claim to C. 1.1.3 Legally binding agreements that are more than just contracts. Some agreements create obligations but also extend beyond contract law. Examples: 1. Marriage. Based on agreement but has public law elements. Cannot be freely dissolved like a contract. Imposes invariable consequences, for example, duty of support. 2. Judgment by consent. Settlement agreements incorporated into court orders. Dual nature, both judicial act and contract. 3. Agreements with public bodies. The state as a contracting party may be subject to different rules. States' contractual rights may be limited by public duties under the Constitution. Administrative justice may require procedural fairness in contract enforcement. 1.1.4 Definition of contract. Contract, agreement between two or more persons intended to create legal obligations. The agreement must be recognized by law to be binding. Even invalid contracts, for example, due to missing validity requirements, are still referred to as contracts. This summary maintains key legal principles while ensuring clarity and conciseness. Let me know if you need any refinements. Next. Page 1.2 Requirements for a valid contract. For an agreement to be legally binding, it must meet the following 6 essential requirements. Consensus. The parties must have a mutual agreement on all material aspects. Capacity. The parties must have the legal ability to contract. Formalities. Certain contracts must comply with prescribed formalities, for example, written and signed agreements. Legality. The contract must not violate statutory law or common law principles. Possibility. The obligations must be capable of being performed at the time of agreement. Certainty. The terms must be clear and definite for enforceability. 1.3 The nature of contract. A contract is a juristic act that produces legal consequences as intended by the parties. It differs from a delict, as a contract is based on agreement, whereas a delict is based on wrongdoing. Characteristics of a contract. Bilateral or multilateral. At least 2 parties are required. A unilateral promise, policitatio, is generally not binding. Promise and performance. Obligations may involve giving something, doing something, facere, refraining from doing something, non-facere. A party may also warrant a state of affairs, for example, car condition. Reciprocity. Most contracts involve exchange of performances, for example, payment for goods. Unlike English law, South African law does not require consideration, quid pro quo. Economic function. Contracts enable the voluntary exchange of goods and services, forming the foundation of the free market system. Formality versus informality. Contracts may be formal, negotiated and documented, for example, commercial agreements. Informal, oral or tacit, for example, purchasing groceries. boarding a bus. Freedom of contract. Parties can contract freely, provided the agreement is possible and lawful. All contracts must be consensual, based on agreement, bona fide, conducted in good faith. _. 1.4 Contract and the Law of Obligations. Contract law is part of private law, specifically the law of obligations. It relates to other branches of obligations, such as delict, obligations arising from wrongful acts; unjustified enrichment, obligations to return undue benefits received without legal justification. This summary maintains depth while ensuring clarity and conciseness. Let me know if you need modifications. Next. Page 1.4.1 The concept of obligation. An obligation is a legal bond, vinculum juris, between two or more parties, requiring a debtor to perform a duty for a creditor. Obligations consist of the creditor's right to demand performance, the debtor's duty to fulfill that performance. Reciprocal obligations in contracts. Most contracts create multiple obligations, making each party both a debtor and a creditor. Example, in a contract of sale, the seller must deliver the item, debtor, and has the right to payment, creditor. Obligations are personal rights, jus in personam, binding only the parties involved, unlike real rights, jus in rem, which apply against the world at large. Types of obligations. Civil obligations enforceable by legal action. Natural obligations not enforceable, but have legal consequences. For example, gambling debts cannot be recovered once paid. Sources of obligations. 1. Contract, obligations voluntarily undertaken. 2. Delict, obligations arising from wrongful conduct. 3. Unjustified enrichment, arising from a shift in wealth without a legal basis. 4. Negotiarum gestio, managing another's affairs without authorization. 5. Family law, wills and statutes, other legal sources. _. 1.4 Contract and delict. Delict, wrongful conduct causing harm, requiring the wrongdoer to compensate the victim, for example, defamation, property damage. Key difference. Contractual obligations, voluntarily assumed by the parties. Delictual obligations imposed by law, regardless of agreement. Breach of contract versus delict. A breach of contract may lead to damages but does not automatically result in delictual liability. Concurrent liability. A single act may give rise to both contractual and delictual claims, for example, a surgeon negligently leaving a swab inside a patient. Claiming in delict requires proof of wrongfulness beyond contract terms. Example, breach of contract only. A machine contract specifies 5,000 bolts per hour, but produces only 3,000, no delict arises. Example, delict applies. If the machine explodes and injures the buyer, delictual liability exists independently of the contract. _. 1.4.3 Contract and enrichment. Unjustified enrichment occurs when wealth shifts without a legal basis, sine causa. The enriched party has a duty to return the enrichment, and the deprived party has a corresponding enrichment action, condictio. Key principles. A valid contract provides a legal basis, causa, for enrichment. If a contract is invalid or fails, any performance made without legal justification is subject to restitution. South African law has extended enrichment remedies beyond the rigid Roman Dutch actions, though no general enrichment action has been fully established. _. Table, comparison of contract, delict, and enrichment. Aspect contract delict enrichment. Source of obligation agreement between parties wrongful conduct causing harm unjustified shift of wealth. Obligation content performance as agreed avoiding harm returning the enrichment. Legal remedy actual performance or compensation for harm restitution of enrichment. This summary maintains a structured, detailed overview of obligations while ensuring clarity and conciseness. Let me know if you need further refinements. Next. Page Study notes, Contract and the Law of Property and the Development of the Modern Notion of Contract. _ 1.5 Contract and the Law of Property. Property, narrow sense, material, corporeal, things like books, cars, farms. Contract law governs interpersonal agreements, personal rights, and duties. Property law governs legal relationships between persons and corporeal things. Real rights, ownership and lesser real rights, for example servitudes, mortgage, pledge, hypothec. Property, broad sense, includes anything with monetary value forming an asset in an estate. Includes immaterial property, copyright, patents, trademarks. Personal rights from contracts, delict, etc. for example, shares, insurance policies, pension rights. Commercial transactions often involve both contract and property law. Examples: sale of a house, contract, agreement to transfer ownership, plus actual transfer, registration. Donation, donor's promise plus physical transfer. Cession, obligationary agreement, duty to cede, plus real agreement, actual transfer. Causa, legal reason for transfer. If contract is invalid, there is no just cause, justa causa, for transfer. Abstract system of transfer, SA law. Ownership transfers regardless of contract validity. If ownership passes without proper cause, sine causa, transferor may have an enrichment action. Risk, if transferee is insolvent, transferor only has a concurrent claim against the estate. Distinction between real and personal rights. If ownership did not pass, transferor could reclaim property via re vindicatio. If ownership passed, transferor only has a personal claim, which may not be fully satisfied if transferee is insolvent. _ 1.6 The development of the modern notion of contract. Modern SA contract law. Derived from Roman and Roman Dutch law, statutes and constitutional values. Influenced by English law. Statutory impact: Consumer Protection Act, National Credit Act, Conventional Penalties Act. African customary law. Recognized as an independent source, subject to the Constitution. Introduces values like Ubuntu, fairness, dignity, social justice. Common law foundations. Despite legislative and judicial developments, core principles still follow Dutch institutional writers. Modern contracts differ from Roman law due to generalization of the contract notion, 17th–18th century. Acceptance of pacta sunt servanda, agreements must be honored. _ 1.6.1 Roman law. Roman law did not have a unified contract theory. Recognize contract categories. Real contracts, agreement plus delivery of thing. Verbal contracts, formal promises, for example stipulatio. Literal contracts, recorded in a ledger. Consensual contracts, created by mere agreement, sale, lease, partnership, mandate. Fundamental principle, ex nudo pacto non oritur actio, bare pacts unenforceable. Stricti juris versus bona fide contracts. Stricti juris, early unilateral contracts, rigid, formalistic. Bona fide, later bilateral contracts, based on good faith. Evolution of contract law. Shift towards informality and commercial necessity. Development of innominate contracts and enforcement of informal pacts. Relaxation of formal rules for stipulations. Roman law never fully enforced all serious agreements. _ 1.6 To Roman Dutch law. Further generalized contract law. Influences: canon law, law merchant, Germanic customs. Discarded strict Roman classifications. Adopted pacta sunt servanda, all serious agreements should be enforced. Contracts became consensual and bona fide. Unresolved issue, meaning of justa causa, just cause. Some writers insisted it was necessary for contract validity. Lack of definition led to legal disputes. _ 1.6.3 Causa and consideration, a celebrated dispute. Late 19th century dispute. Cape Supreme Court, Lord de Villiers CJ. Interpreted justa causa as valuable consideration, quid pro quo. This view aligned with English law. Northern jurists, Justice Kotzer, Transvaal Supreme Court rejected this interpretation as historically inaccurate. Rood v. Wallach rejected consideration as a requirement. Final resolution Conradi v. Rousseau. Appellate Division ruling. English doctrine of consideration does not apply in SA law. Any serious, deliberate agreement is binding if lawful, possible to perform, parties have capacity, ambiguity over iusta causa. Court failed to agree on its meaning. Dominant view, reason/ground of the contract. Alternative view, specific transaction, for example, sale, hire, donation. Over time, iusta causa became redundant. Absorbed into legality and intention to contract, animus contrahendi. Remaining debate. Sambu Nationala Bouvereniging v. Friedman, Janssen J. Questioned whether iusta causa should remain distinct. Unnecessary reliance on iusta causa in later cases. Majority opinion, concept is redundant and should be abandoned. Key case law. 1. Rood v. Wallach rejected the requirement of consideration. 2. Conradi v. Rousseau confirmed consideration is not required in SA law. 3. Sambu Nationala Bouvereniging v. Friedman questioned redundancy of iusta causa. Summary. Contract versus property law. Contracts create personal rights, while property law governs real rights. SA follows an abstract system of transfer. Ownership passes even if contract is invalid, but transferor may have an enrichment claim. Historical development of contract law. Roman law recognized specific contract types, lacked a general theory. Roman Dutch law generalized contract law, Pacta sunt servanda. 19th century dispute. SA courts debated whether consideration was necessary. Final ruling, Conradi v. Rousseau, consideration is not required in SA law. Iusta causa, just cause, once debated, now largely redundant in modern contract law. Would you like additional emphasis on any specific section or case law? Next page. Study notes. Law of contract, Roman law to constitutional impact. 1.6 Roman and Roman Dutch law. 1.6.1 Roman law. Roman law developed over 6 centuries from rigid stricti juris contracts to more flexible bona fide contracts. Roman law did not recognize a general theory of contract but categorized contracts into real contracts, required agreement plus delivery of the thing. Verbal contracts, required prescribed formal words, for example, stipulatio. Literal contracts, required recording a debt in a ledger. Consensual contracts, required mere agreement, for example, sale, lease, partnership, mandate. Ex nudo pacto non oritur actio. Informal agreements, bare pacts, were not enforceable. Contracts were classified as stricti juris unilateral, rigid, formal, early contracts. Bona fide, bilateral, flexible, based on good faith, later contracts, including consensual ones. Development of consensual contracts was driven by commercial needs. Later, innominate contracts and informal pacts gained recognition. Roman law never fully generalized contract enforceability. 1.6 to Roman Dutch law. Roman Dutch law generalized contract law under the principle Pacta sunt servanda. Agreements must be kept. All contracts became consensual and bona fide. Writers continued to insist on iusta causa, just cause, as a necessary element, but failed to define it clearly. 1.6.3 Causa and consideration, a celebrated dispute. Late 19th century, Cape Supreme Court, de Villiers CJ, equated iusta causa with consideration, English law concept of quid pro quo. Resistance from Transvaal Supreme Court. Rood v. Wallach rejected the consideration interpretation. Conradi v. Rousseau settled the issue, affirming that consideration is not part of South African law. Any serious and deliberate agreement is binding if it is lawful, it is possible to perform, parties have capacity to contract. Debate on iusta causa. Some judges saw it as the reason behind the contract. Others linked it to the type of transaction, sale, hire, donation, etc. Modern courts and scholars treat it as redundant. Sambu Nationala Buverinijing v. Friedman questioned the redundancy of Eerste Causa, but the prevailing view is that it serves no real function. 1.7 Impact of the Constitution on Contract Law. Constitutional supremacy and horizontal application. The Constitution applies both vertically, state versus individuals, and horizontally, between private individuals. Courts must invalidate any law or conduct inconsistent with the Constitution. The Bill of Rights affects contract law, ensuring that all principles conform to constitutional values. Direct versus indirect horizontal application. Direct application. A constitutional right is directly invoked in a contractual dispute, for example, attacking a term for violating a fundamental right. Indirect application. The Bill of Rights influences the common law, impacting contract interpretation, for example, arguing that an unfair term violates public policy. Section 39(2) Development of Common Law. Section 39(2) of the Constitution mandates courts to ensure the common law aligns with constitutional values. Courts must actively update the common law to reflect constitutional principles. The Constitutional Court emphasizes 1. Identifying the current common law position. 2. Examining the underlying rationale. 3. Assessing whether it conflicts with constitutional values. 4. Determining the necessary legal amendments. 5. Considering the broader consequences of changes. Separation of powers and legal certainty. Courts recognize the need for legal certainty and avoid unnecessary disruption. Judiciary should not overstep into legislative reform. Section 8. Application of the Bill of Rights. Section 8(1). The Bill of Rights applies to all law and binds government institutions. Section 8(2). Rights can apply to private persons if relevant to the nature of the right and duty. Section 8(3). Courts must develop the common law to enforce constitutional rights if legislation does not. Limit rights under common law only if consistent with Section 36, Limitation Clause. Key cases. 1. Rood v. Wallach, Transvaal Supreme Court, rejected consideration as a requirement. 2. Conradi v. Rousseau, Appellate Division, confirmed that South African law does not require consideration. 3. Sambu Nationala Buverinijing v. Friedman, reopened debate on Eerste Causa but failed to establish it as necessary. 4. Key Constitutional Court rulings reinforced the necessity of aligning common law contract rules with constitutional values. Summary. Roman law, no general contract theory, distinct categories of contracts, rigid formality eased over time. Roman Dutch law generalized contracts under Pacta sunt servanda, removed rigid classifications. Causa versus consideration, South African law rejected consideration, and Eerste Causa is largely seen as redundant. Constitutional impact, the Bill of Rights reshapes contract law, ensuring compliance with fundamental rights. Common law evolution, courts must progressively develop contract law while balancing legal certainty and constitutional values. Next page. Impact of the Constitution on contract law. Application of the Constitution to contract law. The Constitution applies both vertically, state-individual relationships, and horizontally, private-party relationships. Since the Constitution is supreme law, any law or conduct inconsistent with it is invalid. All contract law principles must align with constitutional values and the Bill of Rights. Direct versus indirect horizontal application. Direct application. A provision of the Bill of Rights is directly applied in a dispute without relying on the common law. A party can challenge a contractual term simply for violating a constitutional right. Indirect application. The Bill of Rights influences the common law to determine enforceability. Example, a contractual term violating a fundamental right may be deemed contrary to public policy under common law. Section 39(2) of the Constitution. Courts must develop the common law to align with the Bill of Rights. Ensures that constitutional values guide contractual principles. The Constitutional Court has emphasized the incremental development of common law rather than radical changes. Development of the common law in line with the Constitution. Courts have a general obligation to develop contract law in accordance with Section 39(2). Some commentators advocate for radical transformation, but the Constitutional Court supports cautious reform to maintain legal certainty. Before developing common law, courts must 1. Determine the existing rule. 2. Analyze its justification. 3. Assess whether it conflicts with constitutional values. 4. Propose a modification. 5. Evaluate its wider legal consequences. Courts should respect the separation of powers. Major law reform should be driven by the legislature. Section 8 of the Constitution and horizontal application. Section 8(1). The Bill of Rights applies to all law-binding state institutions. Section 8(2). The Bill of Rights binds private parties where applicable. Section 8(3). Courts must apply or develop common law when enforcing constitutional rights against private parties. Case law analysis, horizontal application of the Constitution. Kumalo v. Holomisa. The Constitutional Court clarified that Section 8(3) requires common law to mediate the direct application of rights in contract law. Barkazan v. Napier. Majority decision. The Constitution should apply indirectly using the public policy test. Direct application under Section 8 would create legal difficulties. Section 36 requires rights limitations to be based on law of general application, which a contract term is not. Lana CJ, minority, some rights may apply directly to contract law. Bidika 231 CCV Trustees for the Oregon Trust. Reaffirmed public policy as the primary route for assessing constitutional challenges to contractual terms. AbbVie Pridewind Preparatory School. The majority supported direct horizontal application. A private school's termination of a student's contract infringed constitutional rights. Section 8(2) directly imposed constitutional duties on the school. Constitutional impact on contractual powers and freedom of contract. Unenforceability of contractual terms. A contract or specific terms may be unenforceable if they violate constitutional rights. Example, a limitation clause may be invalid if it unfairly restricts access to courts. Exercise of contractual powers. Traditionally, courts avoided reviewing how contractual powers were exercised. Now, courts assess whether an action unjustifiably limits constitutional rights. For example, termination of a contract based on unfair discrimination may be invalid. Compelling a party to contract. Normally, parties cannot be forced into a contract. Exception, courts may intervene where refusal to contract constitutes unfair discrimination. Cases. Airline cannot refuse to employ an HIV-positive person. Hairdresser cannot refuse to cut a black person's hair. A baker cannot refuse to sell a cake based on sexual orientation. Diagram 1.1 Indirect application of the Constitution to contract. Highlights how public policy and constitutional values shape contract law. Next page. The basis of contract formation. 1.8.1 Introduction. Modern contract law recognizes that all contracts are consensual, meaning they are based on agreement. Key question: does agreement require a genuine meeting of minds, subjective approach, or merely the appearance of agreement, objective approach? The approach taken influences how courts determine contract formation. 1.8.2 Actual subjective agreement, consensus, genuine agreement concursus animorum, requires that parties intend to contract seriously, agree on material terms, object of contract, price, identity of parties, are conscious of their agreement. Consensus is achieved through communication via words, oral or written. Conduct, implied agreement. Silence, in limited cases. Offer and acceptance model. A makes an offer, which B accepts, creating consensus. 3 aspects of communication. 1. True intention, inner will of A. 2. Expressed intention, as declaration. 3. Perceived intention, B's understanding of as declaration. Ideal scenario, all 3 aspects coincide, forming perfect consensus. _ 1.8.3 Apparent or objective agreement. In practice, a discrepancy may arise between true intention and expressed intention and perceived intention. Reasons for divergence. Mental reservation, a secretly intends something different. Misunderstanding, a poorly expresses intention or B misinterprets it. Effect of dissensus. No actual consensus means no contract, unless an objective appearance of agreement is present. Objective theory of contract. If a party's conduct creates a reasonable belief in agreement, courts may hold them bound. Key factors. The other party's reliance on the apparent agreement. Whether the party at fault created the impression of agreement. Whether prejudice would result from denying contract existence. Example scenario, employment of a mistake. Facts. A person receives a job offer, resigns from their current position, sells their house and makes relocation arrangements. Later, the employer withdraws the offer, stating it was a mistake. Legal question. Can the recipient enforce the contract despite the employer's error? Application of contract theories. Subjective approach, no contract, as there was no real agreement. Objective approach, the employer's conduct created a reasonable reliance, justifying contractual enforcement. Philosophical basis for contractual obligation. Different legal systems vary in their justification for binding individuals to contracts. Continental legal literature has developed various theories on whether subjective or objective elements should dominate contract law. Next. Page 1.8.4 Theories of contract. 1. Will theory. Contract based on individual will. Parties are bound because they chose to be bound. Emphasizes party autonomy, freedom to organize affairs within legal and moral limits. Extremely subjective approach. Requires genuine consensus. No contract if a party is mistaken about material terms. Even if the other party reasonably believes a contract exists, it fails in the absence of actual agreement. Drawbacks. Unfair. Fails to protect reasonable reliance on apparent agreement. Economic uncertainty. Business dealings rely on objective indications of consent. Modern legal systems do not apply it without qualification. 2. Declaration theory. Contract based on external expressions of will, not inner intention. Objective approach. What matters is what parties declare, not what they actually think. Key principle. If A makes an offer and B unambiguously accepts, a contract exists, regardless of actual intent. Drawbacks. Ignores true intentions can result in unintended contracts. Allows disguised transactions, for example, hiding a donation as a sale to avoid tax. No room for mistake doctrine. A party's misinterpretation of terms is irrelevant. Not fully applied in practice due to its rigid and formalistic approach. 3. Reliance theory. Compromise approach. Contract based on detrimental reliance protects reasonable belief in consensus. Semi-objective approach. If A signs a contract that clearly sets out terms, B is entitled to rely on it. If A was mistaken about the contents, B can still enforce the contract if his reliance was reasonable. Balances fairness and legal certainty. Allows contracts to stand in cases of reasonable reliance. However, if reliance was unreasonable, the mistaken party may escape liability. Modern preference corrects weaknesses of will theory without fully embracing declaration theory. Primary role, supplementary basis for contract, used when there is dissensus, lack of actual agreement. Comparison of contract theories, Table 1.2 Theory, will declaration reliance. Basis of contract consensus, concurring will's appearance of consensus, concurring declarations belief in consensus induced by other party. Nature of agreement subjective objective semi-objective. Effect of mistake contract fails contract stands contract fails if reliance unreasonable. Drawbacks fails to protect reasonable reliance favors form over substance secondary basis for contract. Right pointing finger emoji. Conclusion. The reliance theory moderates both extremes and is the preferred approach in modern contract law. Next page. 1.8.5 Approach to contract subjective or objective. 1. South African law's mixed approach. South African contract law blends Roman Dutch law, subjective approach, and English law, objective approach. Initially, South African courts followed the subjective approach but later adopted a generally objective approach to contract formation. Modern position: the subjective approach is the foundation, but the reliance theory corrects its deficiencies in cases of dissensus, lack of true agreement. 2. Roman Dutch law and the subjective approach. Animus comprehendi, intention to contract, and concursus animorum, meeting of minds, were fundamental. Consensus was required. If there was no genuine agreement, no contract existed. Unclear to what extent Roman Dutch writers protected reasonable reliance on an appearance of agreement. 3. English law and the objective approach. English law historically emphasized objective manifestations of intent rather than inner intention. Smith v. Hughes, 1871, established the principle of quasi-mutual assent. If a reasonable person believes that agreement exists based on another's conduct, a contract is formed, even if there is no true consensus. This reliance-based approach closely resembles estoppel and protects reasonable expectations. 4. Key South African cases on contractual approach. 1. I. Peters and Co. v. Solomon. Facts: A offered to pay B's debt to C, believing it was £345, but it was actually £490. C accepted the offer in good faith. Held, C could claim the full amount. The court adopted the objective approach, ruling: if a person expresses an unambiguous offer, and it is accepted in good faith, the contract is binding, regardless of undisclosed mental reservations. 2. South African Railways and Harbours v. National Bank of South Africa Limited. Dictum of Wessels J. The law is concerned with the external manifestations of the parties' minds, not their inner intentions. This statement seemed to adopt declaration theory, but did not reflect the broader subjective protections in South African law. 3. Sambu Nasionale Boevereniging v. Friedman. Jansen Jazz view. Will theory, subjective approach, remains the primary basis. The reliance theory corrects the subjective approach in cases of dissensus. Adopted the Smith v. Hughes principle in South African law. 4. Steyn v. LSA Motors Limited. Facts: during a golf tournament, a car was displayed as a hole-in-one prize. Steyn, an amateur, scored a hole-in-one, but the sponsor argued the prize was only for professionals. Held, no true consensus existed because the offerer, Smell, never intended to offer the prize to amateurs. The court applied the reliance test. Would a reasonable person in the offeree's position believe that the offer represented the offerer's true intention? A reasonable person would have realized the offer was for professionals only, so Steyn's claim failed. 5. Modern approach to contract formation. Starting point: subjective, will, theory. True consensus is the primary basis for contract formation. In cases of dissensus, the reliance theory applies if a party's conduct creates a reasonable belief that a contract exists. The other party relies on this belief to their detriment. Objective test, from Smith v. Hughes. Would a reasonable person in the offeree's position believe a contract exists? Summary of South African contractual approach. Approach description application in SA law. Subjective, will theory, based on real consensus, meeting of minds. Primary basis for contract formation. Objective, declaration theory, based on outward expressions, manifested intent. Historically influential but not fully adopted. Reliance theory protects reasonable belief in consensus. Applied in dissensus cases, for example, Steyn case. South African courts adopt a hybrid approach. 1. Subjective for genuine consensus. 2. Objective, reliance theory, for apparent consensus in dissensus situations. Next page. Approach to contract, subjective or objective. South African law has shifted between subjective and objective approaches to contract formation. Historical influence. Roman Dutch law favored a subjective approach, emphasizing consensus, meeting of minds. English law adopted an objective approach, focusing on reasonable reliance rather than actual intent. English law's objective approach. Case: Smith v. Hughes, 1861, held that a party's conduct can create a contract if it leads a reasonable person to believe there was agreement, even without actual intent. Established quasi-mutual assent, similar to estoppel and the reliance theory. Early South African approach. Followed Roman Dutch principles. Contract requires true consensus. Case: I. Peters and Co. v. Solomon, 1911, adopted the English approach, ruling that an unexpressed mistake does not void a contract if the offer was clearly communicated and accepted in good faith. Case: South African Railways and Harbours v. National Bank of South Africa Limited, 1924. Stated that law considers the external manifestations of intent rather than subjective thoughts. Modern South African approach. Case: Sambu Nasionale Boevereniging v. Friedman, 1979, reaffirmed that consensus is primary, but reasonable reliance can establish a contract if actual agreement is absent. Case: Steyn v. LSA Motors Limited, 1994, confirmed that an offeror's true intention is not irrelevant. Contract formation also considers whether a reasonable person would have believed there was an agreement. Dual basis of contract in modern law. 2 ways to establish a contract in South African law. 1. Consensus, will theory, primary basis. Requires actual agreement, meeting of minds. If proven, no further inquiry needed. 2. Reasonable reliance, reliance theory, secondary basis. Applies when there is no true consensus. If a party's conduct reasonably leads another to believe there is an agreement, the contract is upheld. Comparison with English law. English law starts with the declaration theory, objective approach. The reliance theory is used as a corrective measure. South African law starts with the will theory, but applies the reliance theory in cases of dissensus. Proving the existence of a contract. Burden of proof. The party alleging a contract must prove it. This can be done by showing 1. Consensus, subjective agreement. 2. Reasonable reliance, objective indication of agreement. Evidence considerations. Objective evidence, for example, signed documents, is used to prove subjective agreement. A signed document is prima facie proof of consent. The opposing party can challenge this by proving a justifiable mistake, that the other party knew or should have known about the mistake. The document was misleading, trap for the unwary. Next page. Cornerstones of contract. Consensus and reliance are fundamental to contract law. Other essential principles include 1. Freedom of contract. Parties can choose whether, with whom, and on what terms to contract. Party autonomy. 2. Sanctity of contract. Contracts must be honored and enforced if freely entered into. Pacta sunt servanda. 3. Good faith. Parties should act honestly and fairly. Ubuntu promotes mutual respect. 4. Privity of contract. A contract binds only the contracting parties, not third parties. These principles compete with one another, creating tensions in contract law. Goals of contract law. Contract law provides certainty and fairness in transactions. Key purposes: enforce promises to ensure commercial and legal stability, encourage fair dealings and prevent deception, support private enterprise and the free market economy. Role of the state: ensures contracts are fair and reasonable, prevents coercion or overreaching in agreements, enforces agreements only if justifiable. Competing values in contract law. Sanctity of contract versus fairness in contracts. Sanctity of contract and freedom of contract. Promotes legal certainty and economic stability. Supports individualism and economic liberalism. The state's role should be minimal, ensuring enforcement of freely made agreements. Clear rules enhance predictability, fairness and good faith. Introduces social control to prevent unjust contracts. Courts must ensure fairness and consider public policy. Judicial flexibility allows for justice in individual cases. Balancing these goals is difficult. Strict enforcement of unfair contracts undermines justice. Allowing parties to escape obligations reduces legal certainty. Rigid rules limit fairness. Flexible standards create unpredictability. Historical approach versus constitutional influence. South African law previously favored sanctity of contract, now shifting towards fairness and equity, influenced by constitutional values. Next page. Freedom and sanctity of contract. Rooted in laissez-faire liberalism and individualism, peaked in the late 19th century, associated with classical contract law, as seen in English legal doctrine. Key features of freedom of contract. 1. Party autonomy, freedom to decide whether to contract, with whom to contract, on what terms to contract. 2. Minimal state intervention, the law's role. Courts should only enforce contracts freely entered into. Contracting is like a game of cricket, judges act as neutral umpires. Ensures procedural fairness, not substantive fairness. 3. Clear and certain rules. Contract law should provide predictability for businesses, avoid open-ended judicial discretion. 4. Self-interested individualism. Each party seeks to maximize their own benefit, has no duty to protect the other party's interests. 5. Assumed fairness of exchange. Contracts result from negotiation and bargaining, ensuring mutual benefit. 6. Contracts as discrete events. Contracting is seen as a one-time transaction, does not assume long-term trust or cooperation. Challenges to the classical model. Freedom of contract is not inevitable. In early societies, custom and status dictated obligations, not choice. In collectivist economies, central planning replaces private contracts. Even in Western democracies, freedom of contract is increasingly limited. Faulty assumptions of classical contract law. Classical contract law assumes 1. Equal bargaining power between parties. 2. Perfect or near-perfect market competition. 3. Active negotiation of contract terms. In reality, social and economic pressures force people to contract. Large corporations dominate markets, limiting choice. Most contracts use standard terms, little or no negotiation occurs. Modern challenges and calls for reform. 1. Use of standardized contract terms reduces bargaining power. 2. Welfare state interventions. Governments regulate markets to curb economic hardship. 3. Rise of consumer protection. Shields vulnerable parties from unfair contracts. 4. Growth of human rights protections. South Africa's Bill of Rights influences contract fairness. 5. Regulation of power in contracts. Emphasis on fairness over rigid enforcement. Next page. Good faith, equity, and public policy in contract law. Origins and development of good faith, bona fides, deeply rooted in Roman law, where it introduced equitable principles into contract law. In Roman contract law, Contracts classified as stricti juris, formal, rigid, or bona fide, governed by fairness. Stricti juris contracts were binding even if induced by fraud. To counteract this, the Preta introduced the exceptio doli, defense of bad faith. Exceptio doli specialis, where a contract was induced by fraud. Exceptio doli generalis, where bringing an action itself was an act of bad faith. Bona fide contracts, for example, sale, lease, inherently required good faith, making exceptio doli unnecessary. Good faith in Roman Dutch law. 18th century, Roman Dutch writers recognized all contracts as consensual and bona fide. The exceptio doli became obsolete, but good faith remained an informing principle. Courts expected contractual parties to act in good faith, but the extent of judicial discretion was unclear. The exceptio doli in South African law. Late 19th century, South African courts controversially used exceptio doli to import English doctrines. Estoppel, rectification, and rescission for innocent misrepresentation. Debate on whether exceptio doli could be a standalone defense against unconscionable claims. Some appellate division cases assumed it could be used in extreme inequity cases. Bank of Lisbon and South Africa Limited v. de Ornelis, 1988. Majority ruled that exceptio doli was never part of Roman Dutch law, no basis for a substantive defense based purely on equity. Decision caused academic dismay, but pushed for alternative fairness doctrines. Public policy and good faith in contract enforcement. Sasfin, Proprietary, Limited v. Books, 1989, court struck down a contract that gave a finance company control over a doctor's earnings indefinitely, rendered him powerless to terminate the agreement. Found to be unconscionable, exploitative, and contrary to public interest, court ruled that public policy should ensure simple justice between man and man. Impact of Sasfin. Court did not explicitly refer to good faith, but some argued it revived its role. Good faith seen as a counterbalance to contractual autonomy in public policy considerations. Judicial support for good faith in modern law. Eerste Nasionale Bank van Zuid-like Afrika BPK v. Simon. Olivier Jazz minority judgment emphasized the close link between good faith and public policy. Court refused to enforce suretyship signed by an 85-year-old woman, without legal advice. Held that the bank had a duty to explain or advise independent legal consultation. Supreme Court of Appeals implicit endorsement. Referred to Olivier Jazz judgment with apparent approval. Some Cape judges interpreted this as the green light for developing good faith in contract law, suggested that contract law should align with constitutional values. Key takeaways. Exceptio doli generalis was abolished in Bank of Lisbon, 1988. Public policy, not good faith, became the primary tool for fairness in Sasfin, 1989. Judicial discretion in contract law remains limited, but courts increasingly use public policy and equity. Good faith's role is still debated, with growing support for its relevance in modern contract law. Next page. Debate on the role of good faith in contract law. General consensus. Most agree that parties must negotiate and perform contracts in good faith. However, the exact nature and scope of this requirement remains contested. Key questions in the debate. 1. Is good faith an independent legal principle? Can courts use it directly to intervene in contracts by declining to enforce unfair terms? 2. Is good faith merely an ethical value? Does it serve as an underlying principle like fairness, justice, and reasonableness without direct legal enforceability? 3. What does good faith require from contracting parties? Basic honesty in dealings, or a higher duty to recognize and respect the legitimate interests of the other party? Unresolved issues. Courts struggle to define whether good faith imposes concrete legal obligations or is merely an interpretative guide. Some jurisdictions favor strict contractual freedom, while others recognize a role for good faith in balancing contractual rights and obligations. Next page. Judicial treatment of good faith and fairness in contract law. Supreme Court of Appeals conservative stance. Key cases: Brisley v. Drotsky and York. Position of the court. Good faith, reasonableness, and fairness are abstract values, not independent rules allowing courts to intervene in contracts. These values inform and guide contract law but cannot be directly applied by courts. Allowing judges to refuse enforcement based on subjective fairness would lead to legal and commercial uncertainty. Contractual autonomy is a fundamental right tied to freedom and dignity under the Constitution. Courts must balance contractual freedom with the unacceptable excesses that might undermine dignity and self-respect. Criticism and the Constitutional Court's approach. Criticism: the SCA's rigid stance was widely challenged, leading to questions about the Constitutional Court's position on fairness in contract law. Key case: Barkhazen v. Napier. Issue: a time limitation clause in an insurance contract, requiring claims to be filed within 90 days, was challenged for 1. Unconstitutionality, violating the right to judicial redress under Section 34 of the Constitution. 2. Public policy concerns, being unreasonably harsh and unfair. Norwood J's majority judgment. Public policy is rooted in constitutional values such as fairness, justice, reasonableness, and Ubuntu. Public policy must balance contractual freedom with the prevention of unjust enforcement. Unlike the SCA's position, a term's unfairness or harshness could indeed indicate a constitutional issue. Two-stage test for fairness. 1. Objective fairness of the clause. Does the term, on its face, violate public policy by being manifestly unreasonable? Weigh sanctity of contract against competing values like the right to seek judicial redress. Consider bargaining power between parties. 2. Enforcement in specific circumstances. Even if a clause is generally fair, should it be enforced given the specific hardships faced by the party challenging it? Key takeaways. SCA's approach: strict contractual autonomy with minimal judicial intervention. Constitutional Court's approach. Public policy and fairness are rooted in constitutional values. Courts can refuse enforcement if a contractual term is unjust or unreasonable. The two-stage test balances freedom of contract with fairness and public interest. Next page. Developments in the constitutional role of good faith and fairness in contract law. Diminishing role of good faith in constitutional interpretation. Norwood J's view in Barkhazen. Questioned the limited role of good faith in Brisley v. Drotsky, but did not resolve the issue. Use public policy as the primary tool for incorporating equity into contract law, reducing the need for a separate doctrine of good faith. Concerns following Barkhazen. The ruling suggested courts might refuse to enforce terms purely based on fairness or reasonableness. This interpretation was tested in Bradenkamp v. Standard Bank. The SCA's response in Bradenkamp v. Standard Bank. Facts: bank exercised its contractual right to terminate a customer's account. Judgment by Harms Chair. Barkhazen did not create an overarching requirement of fairness in contract law. A contractual right is not subject to fairness unless it implicates public policy considerations grounded in the Constitution. Reinforced Brisley v. Drotsky, fairness is not a freestanding requirement. Growing constitutional influence on contract law. Everfresh Market v. Shoprite Checkers. Reaffirmed the central importance of good faith and the need to infuse contract law with constitutional values. Bota v. Rich. The Constitutional Court ruled against cancellation of a contract where it would be a disproportionate penalty for breach. Established that fairness is linked to the consequences of enforcement. No reference was made to Bradenkamp, raising uncertainty about contract law's direction. Judicial tension between the SCA and Constitutional Court. SCA's position. A court cannot refuse to enforce a contract solely because it is unfair. Enforceability must be grounded in public policy considerations rather than judicial discretion. Need for clarity. The divergence in approach led to confusion and tension between the courts. Bidika 231 CCV Trustees for the time being of the Oregon, trust provided much-needed clarification. The Baedeker case, resolving the conflict. Facts. Small franchisee businesses, part of a B initiative, failed to renew lease agreements within the required time. The Western Cape High Court ruled in favor of the lessees, applying Botha v. Rich to prevent a disproportionate sanction. The SCA overturned this, asserting that contractual terms must be enforced unless they contravene public policy. Constitutional Court ruling. The majority judgment, by Theron J. upheld the SCA's approach, aligning contract enforcement with public policy considerations. Clarifications. Public policy does not mean courts can refuse enforcement merely because a term is unfair. However, fairness and reasonableness remain important factors in assessing public policy considerations. Botha v. Rich is limited in precedential effect, not a general rule for fairness overriding contract terms. Impact of Baedeker. Established a balanced approach, reconciling the SCA's strict contractual enforcement with constitutional values. Restored certainty in contract law, emphasizing that freedom of contract remains paramount, subject to public policy constraints. Next page. Key principles from Baedeker judgment. 1. Freedom of contract and economic stability. Freedom and dignity are constitutional values that uphold parties' ability to contract even to their own detriment. Pacta sunt servanda, agreements must be honored, is fundamental to economic stability and development. 2. The rule of law and certainty. Legal rules must be clear and predictable so that parties can regulate their conduct with confidence. 3. Constitutional oversight of contract law. Contract law is subject to constitutional control to ensure compliance with constitutional rights and values. The Constitution applies indirectly to contract law through public policy, which is now rooted in constitutional values. Barkhuizen remains the leading authority. Courts may invalidate a contract term or refuse to enforce it if it is contrary to public policy. 4. Balancing contractual sanctity and constitutional values. The principle that contracts must be honored is not absolute and does not override other constitutional rights and values. Ubuntu, which incorporates fairness, reasonableness, and justice, can outweigh the sanctity of contract and the need for certainty in contractual relations. 5. Limits on judicial intervention. Good faith, fairness, and reasonableness are not freestanding grounds for intervention. Courts cannot refuse to enforce a contract simply because it is unfair or unreasonable. A contract term is unenforceable only if its enforcement is so unfair, unreasonable, or unjust that it violates public policy. 6. Botha v. Rich and disproportionality. Botha v. Rich applied only to land sale contracts under the Alienation of Land Act. It did not introduce a general test of disproportionality as an independent reason to refuse enforcement. 7. Judicial duty and public policy. Courts must exercise judgment in refusing to enforce contracts, intervening only in worthy cases. The perceptive restraint principle should not deter courts from fulfilling their constitutional duty to align public policy with constitutional values. Harm to individuals, not just harm to the public, can be a valid public policy concern. 8. Burden of proof and compliance. The party challenging a contract on public policy grounds bears the onus of proof. A party failing to comply with the contract must provide an adequate explanation for non-compliance. 9. Courts' role in developing contract law. Section 39(2) of the Constitution requires courts to align common law with the Bill of Rights. Ubuntu-based values, fairness, reasonableness, good faith, must be carefully integrated into contract law. Courts must develop clear, objective standards to assess fairness in contract enforcement. 10. Future development of contract law. Baedeker provides greater certainty by reconciling the SCA's strict enforcement approach with the CC's constitutional values approach. Fairness and reasonableness will continue to shape public policy, but require concrete legal tests. Future legal development should focus on specific rules for particular contract types, similar to restraint of trade agreements. Frunman J's minority judgment, courts must define cognizable standards for fairness and reasonableness to ensure objective application in contract disputes. Next page. Consumer Protection Act 68 of 2008, CPA 1. Purpose and impact. Fully enforced on 1 April 2011. Significantly influences contract law and business practices in South Africa. Aims to protect consumers from exploitation and promote social and economic welfare. Establishes a legal framework for a consumer market that is fair, accessible, efficient, sustainable, and responsible. Protects consumers from unconscionable, unjust, or unreasonable business practices. 2. Fundamental consumer rights. Right to equal treatment, protection against discriminatory marketing. Right to privacy, protection from direct marketing practices. Right to choose includes freedom to select suppliers, examine and return goods, cooling off periods in certain transactions, cancel advance bookings/reservations, right to disclosure and information, transparent pricing, clear labeling, use of plain language, right to fair and responsible marketing, regulations on bait marketing, direct marketing, and promotional competitions, right to fair and honest dealing, protection from fraud, duress, undue influence, misleading representations, and pyramid schemes, right to fair, just, and reasonable terms, regulated below, right to fair value, quality, and safety, introduces strict no-fault liability for harm caused by defective products. 3. Enforcement and sanctions. Enforced through courts and national consumer protection institutions including National Consumer Commission, NCC, National Consumer Tribunal, NCT, established under the National Credit Act. Non-compliance can result in compliance notices, fines and criminal penalties, contracts declared null and void if they violate the CPA. 4. Scope of the CPA applies to most transactions between suppliers and consumers in South Africa. Covers goods, services, and their promotion. Supplier, any person, juristic person, trust or organ of state who markets goods or services. Consumer includes end user of goods/services, franchisees, small businesses annual turnover/assets below 2 million, exemptions, transactions involving the state, juristic persons with assets/turnover above 2 million. Employment contracts, credit agreements regulated by other laws, ministerial exemptions. 5. Right to fair, just, and reasonable terms. Prohibited contractual terms, void if non-compliant. Defeating the CPA's purpose, misleading, fraudulent, or deceptive terms. Waiving consumer rights or avoiding supplier obligations under the CPA. Limiting supplier liability for gross negligence, falsely stating that no warranties/misrepresentations were made, fairness and reasonableness requirement. Suppliers cannot impose terms that are excessively one-sided, unreasonably adverse to the consumer, induced by false/misleading representations, not properly disclosed before the transaction, exclusion of liability. Ordinary negligence may be excluded if the exclusion is fair and reasonable. It is clearly brought to the consumer's attention before the contract is concluded. Next page. Does the CPA go too far in protecting consumers? 1. Common law versus CPA protections. In many respects, the CPA reaffirms existing common law protections, for example, liability for misrepresentation, duress, undue influence. However, in other areas, the CPA goes much further, providing enhanced consumer protection. South African consumers now enjoy stronger protections than many other jurisdictions. 2. Strict liability for defective products. Organized commerce is concerned about strict, no-fault, liability for defective products. However, this is already standard in many developed economies. This increases the cost of doing business, likely resulting in higher consumer prices. Nevertheless, this trade-off is justified by greater consumer protection. 3. Uncertainty in the fairness test. The test for fairness in contract terms is circular, relying on inequity. Courts have wide discretion in deciding whether a term is enforceable. This raises concerns about legal uncertainty, as noted in Brisley v. Drotsky. However, uncertainty may be no greater than that arising from Barkhazen v. Napier, where public policy considerations already shape contract enforcement. 4. Impact on exemption clauses. Courts have traditionally been reluctant to enforce exemption clauses fully. The CPA strengthens consumer rights, further limiting suppliers' ability to exclude liability. Suppliers may have to rely on insurance to mitigate risks. The cost of insurance may be passed to consumers, potentially leading to higher prices. 5. Conclusion. While the CPA increases consumer protection, concerns exist over increased costs, legal uncertainty, and supplier liability. However, these trade-offs are in line with international trends. The real challenge is ensuring a balanced application of judicial discretion to avoid over-regulation while maintaining fairness in contracts. Next page. Chapter 1 Key Points. 1. Definition and nature of a contract. A contract is an agreement between two or more parties with the intention of creating legal obligations. It is an obligationary agreement, distinct from absolving agreements, discharge obligations, real transfer agreements, transfer rights. 2. Requirements for a valid contract. Consensus between parties, capacity to contract, compliance with formalities, legality of agreement, possibility of performance, certainty of contract terms. 3. Characteristics of a contract. A juristic act, law assigns intended consequences, bilateral or multilateral in nature, entails undertakings to give, dare, do, foresee, or refrain, non-foresee. Most contracts involve reciprocal obligations. 4. Generalization of contracts. Modern law enforces agreements based on general principles, not just specific types. 5. Good faith in contracts. Parties must act in good faith, bona fides. 6. Contract law as part of the law of obligations. Obligation, a legal bond requiring a debtor to perform an act for a creditor. Rights under a contract are personal rights, jus in personam, not real rights. 7. Enforceability of obligations. Civil obligations enforceable by court action. Natural obligations not enforceable, but may be voluntarily performed. 8. Sources of obligations. Contract and delict, wrongful conduct causing harm. Concurrent liability, conduct may be both a breach of contract and a delict. Unjustified enrichment, transfer of wealth without legal cause, sine causa, allowing restitution claims. 9. Contracts and property law. Many contracts have both contractual and proprietary elements. South African law follows an abstract system of transfer, meaning ownership can pass even if the underlying contract is invalid. 10. Historical development of contract law. Roman law recognized only specific types of enforceable contracts. Roman Dutch law expanded contract law with Pacta sunt servanda, agreements must be kept. South African law rejected the need for justa causa, legal justification for a contract. 11. Consensus in contracts. Subjective consensus, actual meeting of minds, ad idem. Divergence in intention, depends on whether the legal system applies a subjective or objective approach. 12. Theories of contract formation. Will theory focuses on actual agreement, but too rigid in practice. Declaration theory focuses on external expressions, but needs qualification. Reliance theory protects reasonable expectations of agreement. South African law, will theory is the starting point, but reliance theory applies in cases of dissensus. 13. Burden of proof. Party alleging the existence of a contract must prove it. 14. Function of contract law. Facilitates business transactions by ensuring agreements are upheld. Regulates private enterprise to ensure fair dealing. 15. Key principles of contract law. Freedom of contract. Sanctity of contract. Good faith. Privity of contract. Only parties to a contract have rights and obligations. 16. Constitutional influence on contract law. Freedom of contract is under pressure due to fairness concerns. Courts increasingly apply good faith, public policy, and Ubuntu. Courts will only refuse enforcement if the contract is so unfair or unreasonable that it violates public policy. Consumer Protection Act 68 of 2008 voids unfair contract terms or subjects them to fairness tests. All contract law is subject to constitutional control. 17. Direct versus indirect application of the Constitution. Debate exists over whether the Constitution directly invalidates contracts. Constitutional Court prefers indirect application, assessing contracts against public policy, as shaped by constitutional values. 18. Judicial intervention in contractual powers. Courts may override contractual powers if exercised unfairly. Courts may even compel parties to contract on constitutional grounds. Next page, Chapter 2, Offer and Acceptance in Contract Law 2.1 Introduction. A contract is formed through offer and acceptance, establishing consensus between parties. The offer is a proposal to contract, and acceptance creates a binding agreement. Underscore 2.2 The offer 2.1 Legal effect of an offer. An offer is a proposal that, once accepted, leads to a binding contract. Distinct from an invitation to negotiate, which lacks contractual intent. 2.2 Requirements for a valid offer. 2.2.1 The offer must be firm. The offeror must have serious intention to be bound by the terms. 2.2 The offer must be complete. Essential terms, for example, price, subject matter, must be clearly defined. 2.2.3 The offer must be clear and certain. No ambiguity regarding rights and obligations of the parties. 2.2.4 The Consumer Protection Act 68 of 2008, CPA, prohibits misleading or deceptive offers to consumers. Ensures fairness and transparency in consumer contracts. 2.3 Offers to the public. 2.3.1 Advertisements generally considered invitations to treat, not offers. Exceptions specific and clear advertisements may constitute offers. 2.2 Promises of reward. Unilateral offers, binding upon performance of the required act. 2.3.3 Calls for tenders. Generally invitations to negotiate unless the tender explicitly states otherwise. Acceptance occurs when the best tender is chosen. 2.3.4 Auctions without reserve. The highest bid constitutes acceptance. With reserve, the seller retains discretion to accept a bid. 2.4 Termination of an offer. 2.4.1 Rejection of the offer. A rejected offer ceases to exist. 2.4 Death of either party. An offer lapses if the offerer or offeree dies before acceptance. 2.4.3 Effluxion of the prescribed or reasonable time. An offer must be accepted within the specified time or a reasonable period. 2.4.4 Revocation of the offer. Offerer may withdraw offer before acceptance unless irrevocable. 2.4.5 Loss of legal capacity to act. If the offerer loses legal capacity, for example, mental incapacity, the offer lapses. 2.4.6 Acceptance of offer. Once accepted, the offer is transformed into a binding contract. Underscore 2.3 The acceptance. 2.3.1 Requirements for a valid acceptance. 2.3.1.1 The acceptance must be unqualified. Any modifications result in a counteroffer, not acceptance. 2.3.1.2 The acceptance must be by the person to whom the offer was made. Third parties cannot accept an offer unless expressly allowed. 2.3.1.3 The acceptance must be a conscious response to the offer. The offeree must be aware of and intend to accept the offer. 2.3.1.4 The acceptance must be in the form prescribed by the offerer. If the offerer requires acceptance in a specific manner, it must be followed. 2.3. When and where acceptance takes effect. 2.3.2.1 The information theory. As the general rule, acceptance takes effect when the offerer becomes aware of it. 2.3.2.2 Exceptions to the general rule. Specific rules apply depending on the method of communication. 2.3.2.3 Where the offerer stipulates a different method of acceptance, offerer can dictate when and how acceptance is effective. 2.3.2.4 Postal contracts. The expedition theory applies. Acceptance occurs when the letter is posted, not when received. 2.3.2.5 The scope of the exception applies only if postal acceptance was contemplated by the parties. 2.3.2.6 Criticism of the expedition theory. Risk is unfairly placed on the offerer. 2.3.2.7 Revocation or neutralization of the posted acceptance. Once posted, acceptance cannot be revoked under expedition theory. 2.3.2.8 Electronic contracts. The reception theory applies. Acceptance occurs when the message reaches the offerer's system. 2.4 Breaking off negotiations. Pre-contractual negotiations do not generally create liability. Exception: bad faith negotiation may lead to delictual liability. 2.5 Pacta de contrahendo. Pre-contract agreements. 2.5.1 Options. 2.5.1.1 Juristic nature of an option. An option is a contract granting exclusive rights to accept an offer. 2.5.1 2 Earlier views on the nature of an option. Debate over whether it is a unilateral or bilateral contract. 2.5.1.3 Unilateral declaration that the offer is irrevocable. South African law requires a separate binding contract to keep an offer open. 2.5.1.4 Legal effect of an option binds the grantor to keep the offer open for the option holder. 2.5.1.5 Duration of the option. An option must specify a time period, otherwise, a reasonable time applies. 2.5.1.6 Transferability of an option. Generally transferable, unless stated otherwise. 2.5.1.7 Formalities. Options to buy or sell land must be in writing to be valid under Alienation of Land Act. 2.5.1.8 Remedies for breach of an option. Damages or specific performance may be claimed. 2.5.2 Preference contracts. 2.5.2.1 Right of preemption gives a party the first right to buy before the seller offers to others. 2.5.2 Right of preemption compared with an option. A preemption right depends on the owner's willingness to sell, whereas an option is a binding offer. 2.5.2.3 The obligations of the grantor must offer the asset to the preemption holder before third parties. 2.5.4 The trigger event in a preemption agreement. The grantor deciding to sell activates the preemption right. 2.5.2.5 The offer must be a bona fide one. The price and terms must be genuine, not a way to bypass the preemption right. 2.5.2.6 Duration of the offer. The offer must remain open for a reasonable time. 2.5.2.7 Formalities. Land preemption agreements must be in writing. 2.5.2.8 Remedies for breach. Specific performance or damages can be claimed. Conclusion. Offer and acceptance create a legally binding contract. Strict legal rules govern validity, termination, and enforceability. Pacta de contrahendo. Pre-contract agreements ensure future contractual certainty. Modern contract law integrates consumer protection and electronic commerce principles. Next. Page 2.1 Introduction. A contract is formed when all material terms are agreed upon, provided other validity requirements are met. The agreement process may be brief or lengthy, depending on negotiations. It involves mutual declarations of intention, analyzed through offer and acceptance. Offer: A proposes terms. Acceptance: B agrees to terms. Counteroffer: B modifies terms requiring as acceptance. The primary basis of a contract is consensus, not the strict application of offer and acceptance rules. Flexibility of offer and acceptance. Offer and acceptance is an analytical tool, not a rigid requirement. Difficulties may arise in identifying the offeror/offeree, for example, when both parties sign simultaneously. As long as consensus is reached, strict distinctions are unnecessary. Modes of expressing intentions. Contract formation may occur through writing, formal contracts; oral communication, spoken agreement; conduct, for example, nodding or raising a hand at an auction; tacit agreement, for example, parking in a garage with posted conditions; silence, in rare cases where prior dealings indicate implied acceptance. Formalities and exceptions. The law may require specific formalities, for example, land sales must be in writing, discussed in Chapter 6. Parties may impose their own contractual formalities. Alternative means of reaching consensus. A clear offer and acceptance is not always necessary for a contract. Long-term relational contracts develop gradually through ongoing interactions, not a single exchange of offer and acceptance. 2.2 The offer. An offer is a proposal to contract containing terms on which the offeror is willing to perform. Can be made to a specific individual, a group of people, the general public, for example, reward advertisements. 2.1 Legal effect of an offer. A contract is a bilateral juristic act requiring agreement from both parties. An offer alone does not create obligations, it merely invites acceptance. Upon acceptance, the contract is formed. Until acceptance, the offeror can withdraw the offer unless bound by an option contract. Option contracts prevent withdrawal and will be discussed later. Next. Page 2.2 Requirements for a valid offer. For an expression of intention to constitute a legally effective offer, it must meet the following requirements. 2.2.1 The offer must be firm. The offer must be made animo contrahendi, with the intent to create legal obligations upon acceptance. A tentative statement to gauge interest is not a firm offer. Determining whether an offer is firm depends on factual circumstances. 2.2 The offer must be complete. The offer must contain all material terms of the proposed agreement. If issues remain to be negotiated, the contract is not yet binding. If parties agree that some terms are binding despite pending issues, a preliminary agreement is enforceable. A preliminary agreement is incorporated into and superseded by the final contract once all terms are settled. 2.2.3 The offer must be clear and certain. The offer must be sufficiently definite so that mere acceptance forms a binding contract. Vague offers, for example, "I will buy your car if it suits me," are unenforceable. Agreements to negotiate in the future are void for uncertainty unless a deadlock-breaking mechanism, for example, third-party determination, is included. If a party is given discretion to determine performance, courts require reasonable conduct, arbitrium boni viri, to avoid abuse. Courts favor upholding agreements, recognizing that businesspeople often rely on good faith and commercial expediency despite imperfect drafting. Mouton v. Hanekom, offer to perform when financially able was not too vague to be enforceable. 2.2.4 The Consumer Protection Act 60 of 2008, CPA. The CPA imposes additional requirements for valid offers. Plain and understandable language. Notices, documents, or visual representations must be clear for an ordinary consumer to understand without undue effort. Disclosure of reconditioned or gray market goods. Under Section 25, sellers must clearly indicate if goods are reconditioned, rebuilt, or remade while bearing the original trademark. Prohibition of negative option marketing. Under Section 31, suppliers cannot market goods, services where they are supplied unless the consumer actively declines. Contracts formed through negative option marketing are void. Cooling off period for direct marketing. Under Section 16, consumers can rescind contracts within 5 days of contract conclusion, or goods delivery, whichever is later. The supplier must inform the consumer of this right. Regulation of catalog marketing. Under Section 32(1), suppliers selling through catalogs, telephone, or postal orders must disclose supplier's name, license and registration number, physical address and sales record information, currency of payment, delivery details, cancellation/return/exchange/refund policies, complaint procedure. Next page. Study notes, requirements for a valid offer and offers to the public. 2.2.2 Requirements for a valid offer. An expression of intention constitutes a valid offer if it meets specific requirements. 2.2.2.1 The offer must be firm. The offer must be made animo comprehendi, intention to create a binding contract. Statements made merely to gauge interest are not offers. Determining if a statement is a firm offer is a factual question based on circumstances. 2.2.2 The offer must be complete. All material terms must be included. If essential terms remain to be negotiated, there is no binding agreement. If parties intend for a partial agreement to be binding, it is enforceable. A preliminary agreement can later be incorporated into a comprehensive contract. 2.2.2.3 The offer must be clear and certain. The offer must be specific enough that the offeree can accept it with a simple yes. Offers that are too vague, for example, I will buy your car if it suits me, are void for vagueness. Agreements to negotiate are unenforceable unless a deadlock-breaking mechanism exists, for example, independent third-party determination. An agreement allowing one party to determine the other's performance is valid if exercised reasonably, arbitrium boni veri. Courts distinguish between ambiguity, resolvable via interpretation, and vagueness, void agreement. Case law, Mouton v. Hanacombe, an offer to perform based on financial ability, is not too vague. 2.2.2.4 Consumer Protection Act 68 of 2008, CPA, plain language requirement, notices, documents, and visual representations must be in a form understandable to an average consumer. Disclosure of reconditioned or gray market goods, as per Section 25 CPA, such goods must be conspicuously labeled. Negative option marketing prohibited. Section 31 CPA voids agreements induced by failure to decline an offer. Cooling off period for direct marketing. Section 16 CPA allows consumers to cancel contracts within 5 days of conclusion or delivery. Catalog marketing regulation. Section 32 CPA. Supplier must disclose business details, payment currency, delivery terms, cancellation policies, and complaint procedures. 2.2.3 Offers to the public. An offer is typically addressed to an individual but can be made to the public or a segment of it. Case law, Carlyle v. Carbolic Smoke Ball Company, an offer to the public is binding if accepted by performance. 2.2.3.1 Advertisements. General rule: advertisements are invitations to do business, not offers. Case law, Crawley v. Rex, a shop advertisement is an invitation to negotiate, not a binding offer. Advertisements must not mislead consumers. Section 31 CPA prohibits bait marketing. Supermarkets and offers. Unsettled in South African law, but may follow Pharmaceutical Society of Great Britain v. Boots Cash Chemists, where the customer makes the offer at checkout. 2.2.2 Promises of reward. Rewards for acts, for example, finding lost property, are considered offers to the public. Case law, Bloom v. American Swiss Watch Company, a person must have knowledge of the reward to accept the offer. 2.2.3.3 Calls for tenders. Invitations for tenders are not offers but requests for proposals. Submitted tenders are offers that can be accepted or rejected. 2.2.3.4 Auctions. Key issue: who makes the offer? Determined by auction conditions. Without reserve, auctioneer makes the offer, bidder accepts. With reserve, bidder makes the offer, auctioneer accepts. Presumption: auctions are subject to reserve. Consumer Protection Act, CPA, regulations. Section 45.3, sale is final when announced by auctioneer, for example, fall of hammer. Section 45.4, advance notice required for reserve price or right of seller to bid. Failure to disclose these conditions allows consumers to challenge the sale as fraudulent. These notes comprehensively summarize the key legal principles regarding offers, ensuring clarity on contract formation, advertisements, rewards, tenders, and auctions. Let me know if you need further elaboration on any section. Next page. Study notes. Termination of an offer. 2.4 An offer is not open indefinitely and can be terminated under the following circumstances. 2.4.1 Rejection of the offer. An offer is terminated if the offeree expressly or impliedly rejects it. Implied rejection occurs when the offeree makes a counteroffer, which constitutes a new offer. The offeree gives a qualified acceptance, for example, acceptance subject to conditions. 2.4 Death of either party. The death of either the offerer or the offeree terminates the offer. Since an offer does not create obligations, no rights or debts pass to the deceased estate. Exception: if the offerer has granted an option contract, a promise to keep the offer open, the offer remains valid despite death. 2.4.3 Expiry of prescribed or reasonable time. If the offerer sets a time limit, the offer lapses automatically once the period expires. If no time limit is set, the offer expires after a reasonable time, determined by the facts of the case. The existence of a time limit does not mean the offerer cannot revoke the offer before the expiry, unless it is part of an option contract. 2.4.4 Revocation of the offer. The offerer can revoke the offer at any time before acceptance, unless bound by an option contract. Revocation is only effective once communicated to the offeree. If the offeree accepts before learning of the revocation, a contract is formed. 2.4.5 Loss of legal capacity to act. If either the offerer or offeree loses legal capacity, for example, mental incapacity or insolvency, the offer is terminated. 2.4.6 Acceptance of the offer. Once the offeree accepts, the contract is concluded, and the offer ceases to exist. This summary covers key termination principles. Let me know if you need case law references or further elaboration. Next page. Study notes. Acceptance. 2.3 Definition. Acceptance is a clear and unambiguous declaration, by the offeree, assenting to all terms of the offer. It may be express, for example, I accept, or tacit, for example, nodding in agreement. Silence is not acceptance. An offerer cannot impose a contract through unsolicited goods with an assumption of acceptance. 2.3.1 Requirements for a valid acceptance. 2.3.1.1 Acceptance must be unqualified. Mirror image rule. Acceptance must be an exact match to the offer. If acceptance is conditional or introduces new terms, it becomes a counteroffer rather than a valid acceptance. Ambiguous acceptance, for example, I am interested, but I need to check my finances, does not form a contract. 2.3.1.2 Acceptance must be, by the intended offeree. If an offer is public, anyone in that class may accept. If an offer is made to a specific person, only that person can accept. Case, Bird v. Somerville. A written offer was made to a sole purchaser. Two people signed as buyers. The court held the offerer was not bound to both buyers, as he had not intended to contract with both. Cessionary and public offers. A cessionary, a third party who takes over rights, can accept an offer if option rights allow it. Offers of reward can be accepted by any member of the public. 2.3.1.3 Acceptance must be a conscious response to the offer. Case, Bloom v. American Swiss Watch Company. A reward was offered for information leading to an arrest. The claimant gave information before knowing about the reward. The court held that acceptance requires knowledge of the offer, and the claimant was not entitled to the reward. 2.3.1.4 Acceptance must follow any prescribed form. The offerer may prescribe a method of acceptance, for example, acceptance must be in writing. If a method is prescribed, no other form of acceptance is valid unless the offerer's wording is not exclusive, for example, Please reply by post may allow other forms. The reliance theory applies if the offeree leads the offerer to reasonably believe the acceptance was valid. Case, Pillay v. Sheikh. The Supreme Court of Appeal held that if an offeree creates a reasonable belief that acceptance followed the prescribed method, it may still be valid. Let me know if you need additional case law analysis. Next page. Study notes: when and where acceptance takes effect. General principles. A contract is formed when an offer is accepted. If parties contract in each other's presence, inter presens, acceptance is immediate. If parties contract at a distance, inter absens, there may be a time lag between declaration and ascertainment of acceptance. Determining the time and place of acceptance is crucial for checking whether acceptance was timely, establishing if an offerer's revocation was too late, determining when prescription begins, establishing jurisdiction in legal disputes. Theories on when a contract is concluded. Declaration theory: contract forms when the offeree expresses acceptance, for example, writes or signs a letter. Expedition theory: contract forms when the offeree posts the acceptance letter. Reception theory: contract forms when the acceptance letter reaches the offerer's address. Information theory: contract forms when the offerer becomes aware of the acceptance. 2.3.2.1 Information theory as the general rule. Main principle: a contract is concluded when the offerer learns of the acceptance. Rationale: actual and conscious agreement is necessary for consensus. 2.3.2.2 Exceptions to the general rule. 1. Offerer stipulates a different method of acceptance. 2. Postal contracts, expedition theory applies. 3. Electronic contracts, reception theory applies. 2.3.2.3 Offerer stipulates a different method of acceptance. The offerer may waive the requirement for communication of acceptance. A waiver may be express or implied. Examples from case law. Contract formed when an offer is signed, when goods are dispatched, when written notice of acceptance is delivered to a designated address. In a reward contract, when the offeree performs the required action, for example scoring a hole-in-one. 2.3.2.4 Postal contracts, expedition theory applies. Cape Explosive Works Limited v. S.A. Oil and Fat Industries, Cape Explosive Works Limited v. Lever Brothers, S.A. Limited. Court held that contracts were concluded when letters of acceptance were posted. Justifications. Commercial convenience. Protection of the offeree, certainty of acceptance, presumption of proper postal service functioning. The post office is not the offerer's agent. Confirmed in Kerjuland Sealing and Whaling Company Limited v. Commissioner for Inland Revenue. 2.3.2.5 Scope of the exception. Expedition theory applies if black tick mark emoji, offer is made by post. Black tick mark emoji, postal services are functioning normally. Black tick mark emoji, offerer has not indicated a contrary intention. Black tick mark emoji, contract is commercial. Expedition theory does not apply to multiplication sign emoji, telephone or email contracts. Multiplication sign emoji, contracts concluded inter presens, even if a reply by post was anticipated. Smiman v. Volkers. 2.3.2.6 Criticism of the expedition theory. Cape Explosive Works principle has been widely criticized. Incorrect assumption of waiver. Posting an offer does not imply waiving notification of acceptance. Unfair risk allocation. Offerer bears the risk of lost acceptance letters. Logical inconsistency. If acceptance is posted, it cannot be revoked even if intercepted before reaching the offerer. A to Z Bazaars Proprietary Limited v. Minister of Agriculture. Court acknowledged criticism but upheld precedent. 2.3.2.7 Revocation or neutralization of posted acceptance. Expedition theory prevents revocation once a letter is posted. Equitable considerations suggest: if offerer is at fault, wrong address, fail to update address, offeree should rely on contract. If offeree is at fault, incorrect address, offerer should dispute contract. If no fault, applying the expedition theory may be unjustified. 232.8 Electronic Contracts, Reception Theory applies. Governed by Electronic Communications and Transactions Act, contract forms when and where acceptance is received by the offerer. A data message is considered received when it enters the offerer's designated information system. It is retrievable and processable by the offerer. Next. Double it. Page. Study notes when and where acceptance takes effect. 232 General Principles. A contract is formed when an offer is accepted. If parties contract in each other's presence, inter presence, acceptance is immediate. If parties contract at a distance, inter absence, there may be a time lag between the declaration and ascertainment of acceptance. Determining the time and place of acceptance is crucial for several legal and practical reasons. Timeliness of acceptance, ensuring that the acceptance was made within the required time frame. Validity of revocation, establishing whether the offerer's revocation was too late. Prescription and limitation periods, determining the moment contractual obligations arise. Jurisdiction in legal disputes, identifying which legal system governs the contract if parties are in different locations. 232.1 Theories on when a contract is concluded. Several legal theories have been proposed to determine when a contract comes into effect. 1. Declaration theory. A contract is concluded when the offeree expresses acceptance, such as signing a letter or verbally accepting the offer. 2. Expedition theory. A contract is concluded when the offeree posts the acceptance letter, only applicable to postal contracts. 3. Reception theory. A contract is concluded when the acceptance letter reaches the offerer's address, even if they have not yet read it. 4. Information theory. General rule. A contract is concluded when the offerer becomes aware of the acceptance. This theory ensures that both parties have actual and conscious agreement before being legally bound. 232 Exceptions to the general rule. Information theory. While the information theory is the default rule, there are notable exceptions. 1. Offerer stipulates a different method of acceptance. 2. Postal contracts, expedition theory applies. 3. Electronic contracts, reception theory applies. 232 Offerer stipulates a different method of acceptance. The offerer has the power to dictate the method of acceptance, which can override the general rule. Such stipulations can be express, clearly stated in the offer. For example, acceptance is valid upon signing. Implied, arises from the nature of the transaction. Examples of implied waiver of communication requirement. Contract is concluded when the offeree signs the contract, for example, rental agreements. Contract is concluded when goods are dispatched, for example, commercial sales contracts. Acceptance is valid when written notice is delivered to a specific address. In reward contracts, acceptance occurs when the offeree performs the required action, for example, scoring a hole-in-one in a golf contest. 232.4 Postal contracts, expedition theory applies. Key case, Cape Explosive Works Limited v. SA Oil and Fat Industries Limited, Cape Explosive Works Limited v. Lever Brothers, SA, Limited. The expedition theory applies to postal contracts, meaning the contract is concluded when the acceptance letter is posted. Justifications. 1. Commercial convenience ensures contracts can be finalized without delays. 2. Protection of the offeree prevents the offerer from revoking the offer after the offeree has accepted. 3. Presumption of reliability assumes that postal services function properly. Confirmed in Kerguelen Sealing and Whaling Company Limited v. Commissioner for Inland Revenue. 232.5 Scope of the expedition theory. For the expedition theory to apply, the following conditions must be met. Black tick mark emoji, the offer was made by post. Black tick mark emoji, the postal services were functioning normally. Black tick mark emoji, the offerer has not stated otherwise. Black tick mark emoji, the contract is commercial in nature. However, The expedition theory does not apply in the following cases. Multiplication sign emoji, if communication occurs via telephone, email, or instant messaging. Multiplication sign emoji, if the contract was concluded in person inter presence, even if a reply by post was expected. Multiplication sign emoji, if there is evidence that the offerer required actual notification. Key case, Smiman v. Volkers. The court ruled that if parties communicate in person but later use the post, the expedition theory does not apply. 232.6 Criticism of the expedition theory. The expedition theory, though established in case law, has been widely criticized for several reasons. Incorrect assumption of waiver. Just because an offer is made by post does not mean the offerer waives the right to receive notification of acceptance. Unfair risk allocation. The offerer bears the risk if the acceptance letter is lost, while the offeree is immediately bound. Logical inconsistency. If an acceptance letter is posted but intercepted before delivery, the offeree remains bound, but the offerer is unaware of the acceptance. Key case, A to Z Bazaars Proprietary, Limited v. Minister of Agriculture. The court acknowledged the criticisms of the expedition theory, but upheld the precedent, reinforcing that postal contracts remain valid upon posting of acceptance. 232.7 Revocation or neutralization of posted acceptance. The expedition theory prevents revocation once an acceptance letter is posted. However, equitable considerations suggest that if a dispute arises over lost or delayed acceptance, different fault-based principles should apply. 1. If the offerer is at fault, for example, provided an incorrect address, the offeree should be able to rely on the contract. 2. If the offeree is at fault, for example, mailed acceptance to the wrong address, the offerer should have the right to dispute the contract. 3. If neither party is at fault, applying the expedition theory may be unjustified. 232.8 Electronic contracts, reception theory applies. Electronic Communications and Transactions Act governs contracts made via email, text, or online platforms. The reception theory applies, meaning the contract is concluded when the acceptance is received by the offerer. A data message is considered received when 1. It enters the offerer's designated information system, for example, email server. 2. It is retrievable and processable by the offerer. Summary table theories on contract formation. Theory moment of contract formation applicability. Information theory when the offerer becomes aware of the acceptance general rule. Declaration theory when the offeree expresses acceptance used in face-to-face agreements. Expedition theory when the acceptance letter is posted postal contracts only. Reception theory when the acceptance enters the offerer's information system electronic contracts. This concludes the detailed study notes on when and where acceptance takes effect, covering general principles, legal theories, exceptions, and case law relevant to contract formation. Next page. Study notes, breaking off negotiations and pacta de contrahendo. 2.4 Breaking off negotiations. General rule, parties are free to terminate negotiations at any time. However, expectations may arise that a contract will be concluded, leading to legal consequences if a party has incurred expenditure in reliance on the expected contract. That party will suffer losses due to the other party breaking off negotiations. Good faith and objective reasonableness in negotiations. Many legal systems impose normative restrictions on breaking off negotiations. Entering into negotiations creates an obligation of good faith. Each party must consider the expectations and interests of the other party. Unjustified withdrawal might lead to liability for damages. South African law on breaking off negotiations. Principle of good faith. Recognized by South African courts in pre-contractual negotiations. However, courts have not fully determined its legal implications. Delictual liability. Generally, a party will not be liable for breaking off negotiations. A party who incurs expenditure in anticipation of a contract takes a calculated business risk. However, If reliance on the negotiations is reasonable, damages may be awarded. _. 2.5 Pacta de Contrahendo. Definition: an ancillary agreement concerning the future conclusion of a contract. A binding contract that governs future contractual relations. Types of Pacta de Contrahendo. 1. Option contract, makes an offer irrevocable for a period. 2. Preference contract, right of first refusal, preemption, one party must give the other first opportunity to contract if they decide to proceed. _. 2.5.1 Options. Definition: a contract where the offeror agrees not to revoke the offer for a set time. Effect: the offeree gains the sole right to accept or reject the contract. The offerer cannot withdraw the offer within the agreed period. The main agreement comes into effect if the option holder accepts. Commercial use of options. Example 1. Car sale. A offers to sell a car to B for $130,000. B needs time to raise the money. A grants B a 3-day option to accept the offer without revocation. Example 2. Real estate offer. B signs an offer to purchase document stating that the offer is irrevocable for 30 days. A has 30 days to accept or reject the offer. Example 3. Diamond prospecting. A wants to prospect for diamonds on B's farmland. A pays B $100,000 for an option to buy the land for $10 million if diamonds are found. If diamonds are found, A can exercise the option and buy the land. Example 4. Commercial lease. ABC stores leases space in a shopping mall for 15 years. The contract includes an option to renew the lease for another 10 years. Characteristics of an option contract. Ancillary agreement, linked to a main contract, for example sale, lease. May be free or paid for, can be granted gratuitously or for consideration, for example, a $100,000 paid for an option. Types of options. Call option, right to buy an asset at a fixed price. Put option, right to sell an asset at a fixed price. Transferability. Some options are personal, exercisable only by the grantee. Others are transferable, allowing trading on financial markets, for example, oil or stock options. Example of a transferable option. A holds an option to buy 1 million barrels of oil at $100 per barrel in 2 years. Current price, $70 per barrel. If the market expects oil to rise to $150 per barrel, A can sell the option at a high price. Conclusion. Breaking off negotiations is generally allowed, but reliance on negotiations may justify damages. Pacta de Contrahendo are contracts about contracting and ensure future contractual certainty. Options grant exclusive rights to accept a contract within a set period, and are valuable commercial tools. Next page. Study notes. Juristic nature of an option. 2.5.1.1 Juristic nature of an option. Definition of an option. Comprises 2 elements. 1. Main offer, the offer to enter into the main agreement. 2. Agreement to keep offer open, a separate contract that ensures the main offer remains open for a fixed period. The main offer is the subject matter of the option contract. Requirements for validity. An option is a contract and must satisfy all contract law requirements, including consensus. Formation is based on offer and acceptance, but this involves 2 separate offers. 1. The main offer, for example, an offer to sell a car. 2. The offer to keep the main offer open, the option contract. Unilateral promises. South African law does not recognize unilateral promises as binding unless accepted. Example, A offers to sell a car to B for $100,000, with an option until Monday midnight. If B immediately accepts/rejects the main offer, the option falls away. If B says, "I'll think about it," he has accepted the option contract, but not the main offer. If B accepts the main offer before Monday midnight, he has exercised the option and concluded the sale. If B rejects the main offer before Monday midnight, the sale does not happen, and the option is discharged. If B does not respond by Monday midnight, the main offer lapses along with the option. _ 2.5.1 To earlier views on the nature of an option. Early confusion. Courts did not fully recognize that an option is a contract separate from the main agreement. Some early cases incorrectly equated the option with the main offer. Key cases on the nature of an option: Van Pletsen v. Henning. Solomon J. stated that an option is unilateral and becomes bilateral once accepted. This wrongly equated an option with the main offer, treating it as a binding contract upon acceptance. Boyd v. Nell confirmed Solomon J.'s view, treating an option as a unilateral contract that only becomes bilateral when exercised. Hirsch v. Nell. Davis Asia criticized the unilateral contract theory, stated that an option is a separate agreement between two contracting parties, emphasized that legal consequences arise before the option is exercised, clarified that an option is not merely an offer to sell, but a legally binding contract in its own right. Alternative view: option as a contract subject to a suspensive condition. Theory: an option to buy/sell is a sale contract with a suspensive condition, the condition being the option holder's decision to exercise the option, rejected by the appellate division in Inventor v. Birchholtz. Conclusion: an option is a distinct contract, comprising an offer plus an agreement to keep that offer open. South African courts initially misunderstood the nature of an option but later clarified that an option is not a unilateral contract. It is not just an offer to sell, but a binding contract with legal consequences. The suspensive condition theory was rejected. Next page. Study notes: juristic nature of an option. Continued 2.5.1.3 Unilateral declaration that the offer is irrevocable. Issue: can an offeror render an offer irrevocable through a unilateral declaration, or is granting an option the only way? Legal position: since South African law does not recognize unilateral promises as binding, a declaration of irrevocability should be treated as an offer of an option, requiring acceptance to be binding. Acceptance may be tacit, but treating silence as acceptance creates a legal fiction. Labor Appeal Court's view: an offer stated as irrevocable for a given period becomes irrevocable upon receipt by the offeree, unless expressly rejected. Requiring mental acceptance is impractical since it cannot be evidenced. Requiring express notification of acceptance is unnecessary in normal business practice. 2.5.1.4 Legal effect of an option. Rights and duties created. Grantor's obligations, dual negative duties. 1. Not to withdraw or attempt to withdraw the main offer. 2. Not to interfere with the coming into existence of the main contract, for example, selling the property to a third party. Grantee's rights: to insist that the offer remains open. To ensure the preferential right to acquire the property is not prejudiced. Effect of an option: renders the offer irrevocable. An attempted revocation is ineffective. The offer remains open for the full option period. The grantee may ignore a purported revocation and still exercise the option. However, practical steps should be taken, for example, seeking an interdict, to prevent third parties from acquiring rights in good faith. 2.5.1.5 Duration of the option. Specified time period. If an option agreement stipulates a deadline, failure to exercise it within the period results in automatic termination. No specified time period. The option may be void for vagueness. However, courts may require the offer to remain open for a reasonable time. Death of a party. The death of either party does not automatically terminate the option unless the contract states otherwise. If an option is personal to the grantee, it lapses upon the grantee's death. Other causes of termination. Express rejection by the grantee. Supervening impossibility that prevents performance. 2.5.1.6 Transferability of an option. General rule. Personal rights may be transferred by cession, unless the contract states otherwise. If A grants an option to B, B can cede the rights to C unless the option is expressly or impliedly personal to B. Key consideration: whether the identity of the option holder is important to the grantor. Presumption of transferability. Options to buy for cash are presumed cedable unless the agreement states otherwise. Options involving credit or loans are not freely transferable, as the grantor's assessment of the grantee's financial position is crucial. _ 2.5.1.7 Formalities, options to buy or sell land. Issue: if the main contract, for example, a sale of land, must comply with formalities, must the option contract also comply? Alienation of Land Act, Section 2(1). Sale of land must be in writing and signed by the parties. Legal debate. Some courts initially held that an option contract is separate and does not need to comply with the same formalities. However, in Hirschowitz v. Mollman, the appellate division ruled that an option must meet the same formal requirements as the main contract. Constitutional Court Decision, Mokorne v. Tassos Properties CC. Overruled Hirschowitz. Held that the formal requirements of the Alienation of Land Act do not apply to an option contract. The ruling clarified that an option is a separate contract and does not need to be in writing to be enforceable. Next page. Study notes: remedies for breach of an option. 2.5.1.8 Remedies for breach of an option. General principle: the breach of an option contract is governed by general contract law principles. A material breach gives the innocent party a choice. 1. Cancel the contract and claim restitution and damages. 2. Uphold the contract and claim specific performance. In either case, the innocent party may claim damages for financial loss. Types of damages. Positive interest damages. Aim to place the innocent party in the financial position they would have occupied if the breach had not occurred. Include reliance losses, for example, wasted expenditure incurred in preparing for contract performance. Expectation losses, for example, lost net profit from the contract. Case example: A grants B an option to buy land. Facts: B pays A 400,000 for an option to buy land for R10 million, valid for 6 months. B incurs expenses, market research, advertising, legal work, etc. A breaches by selling the land to C before B exercises the option. B's choices. 1. B cancels the option contract. The option terminates immediately. B is entitled to restitution of the R400,000 paid for the option. Claim for damages depends on B's intention. If B would not have exercised the option, expenditure was wasted anyway. No claim for reliance loss. No lost profit from the sale or development. Possible claim for loss of resale profit, if option was transferable. If B would have exercised the option, reliance expenditure, market research, legal work, etc. is recoverable as damages. If B proves she would have made a net profit from the development, she can claim that profit as damages. Damages equals reliance loss plus net lost profit, placing B in the position she would have been, but for as breach. 2. B holds A to the option. As offer to sell remains intact since it cannot be withdrawn during the option period, B can obtain an interdict to prevent A from transferring the land to C. This amounts to specific performance of the option contract. If B exercises the option is discharged and a contract of sale is created. B can claim transfer of the land as specific performance of the sale contract. Competing claims to transfer. B versus C. B's claim prevails if her option existed before the sale to C. Qui prior est tempori potior est juri, first in time, first in law. C has a claim against A for breach of contract. If A has already transferred the land to C, C as a bona fide successor, good faith buyer for value, C's real right prevails and B is left with a damages claim against A. C as a mala fide successor, aware of B's option, C may be compelled to transfer the land to B. Doctrine of notice applies. C as a lucrative successor, received land without value, for example, a gift. Some authorities suggest B may compel transfer from C. Regardless of the outcome, if B suffers financial loss, she can claim damages from A. Next page. Study notes, preference contracts. 2.5. 2 Preference contracts. Definition. A preference contract is an ancillary agreement where the grantor commits to giving preference to the grantee should the grantor decide to enter into a main agreement. Common example, preemption agreement, right of first refusal in a sale. If the main agreement is not a sale, for example, a lease, it is referred to as a contract of first refusal. General principle, the same legal principles apply to all types of preference contracts. 2.5. 2.1 Right of preemption. Definition. A right of preemption gives the grantee preferential rights to buy a property if the grantor chooses to sell. The grantor is not obliged to sell, the right is conditional on the grantor's decision to sell. Forms of preference. The contract may require 1. Grantor must offer the property to the grantee first. 2. Grantor must notify the grantee of the intention to sell, allowing the grantee to make an offer. The first form, grantor making an offer to the grantee, is more common and will generally be assumed if not explicitly stated otherwise. Key feature. The preemption right does not amount to an obligation to sell, it is only a preferential right to purchase if a sale is contemplated. 2.5. 2 Right of preemption versus option. Option preemption agreement. Main offer already exists. No offer exists yet. Grantor is obliged to sell if the grantee exercises the option. Grantor is never obliged to sell. Power lies with the grantee, they can accept the offer and enforce the sale. Power lies with the grantor, they decide whether to sell. All terms of the sale must be certain, or the option is void for uncertainty. Terms of sale need not be predetermined. Key differences. Option contract, the grantor has already made a firm offer, and the grantee has the power to accept. Preemption agreement, no offer exists yet, only an undertaking to offer if a sale is considered. Legal certainty. Options require all essential terms of the sale to be included. Preemption agreements do not require predetermined sale terms, except for the preemption right itself. Special case. If a preemption agreement includes predetermined sale terms, it may be treated as a conditional option in favor of the grantee. Next page. Study notes, obligations in preemption agreements. 2.5. 2.3 Obligations of the grantor. General rule, obligations depend on the terms of the agreement. If terms are unclear, common law default rules apply. Negative obligation. A preemption agreement restricts alienation. The grantor cannot sell to third parties without first offering the property to the grantee. The grantee has a correlative legal right to prevent a sale that breaches the agreement. Positive obligation, unclear in law. Oceanic v. African Consolidated Theatres, Proprietary, Limited. Bota Ja, no enforceable duty to sell. Ogle v. Thompson Ja, grantor must make an offer if the trigger event occurs. Prevailing view, grantor must make an offer to the grantee once the trigger event happens. The exact obligation depends on the contract terms. Common case, grantor must make an offer to the grantee. Alternative, grantor must invite an offer from the grantee. 2.5. 2.4 The trigger event in a preemption agreement. Trigger event, the condition that activates the grantor's obligation to offer the property to the grantee. Negative obligation, not selling to third parties, applies immediately, but the positive obligation is conditional on the trigger event. Interpretation issue. In Oceanic case, the dispute was whether granting a third party an option, exercisable after a lease ended, triggered the preemptive right. The court was divided, 3-2, with the majority holding that the right had not been triggered. General rule, if contract is silent. A valid offer to a third party or a contract with a third party should be the minimum requirement for the trigger event. Underscore. 2.5. 2.5 The offer must be a bona fide one. Once the trigger event occurs, the grantor cannot evade obligations by making an unreasonable offer. Bona fide offer requirements. If the preemption agreement specifies sale terms, the offer must follow those terms. If a third party makes a genuine offer, the grantee must match those terms, even if the price exceeds market value. If the grantor has granted an option to a third party, the offer to the grantee must be on no less favorable terms. If none of the above applies, courts may assess market value and other objective factors to determine fairness. Underscore. 2.5. 2.6 Duration of the offer. Roman Dutch law, the offer had to be open for at least 2 months. Modern law, the offer must be kept open for a reasonable period unless the contract states otherwise. Good faith principle. The grantor cannot withdraw the offer immediately to avoid obligations. In Wissakerka v. Wissakerka, the court ruled that if the grantor genuinely changes their mind and no longer wishes to sell, they may withdraw the offer. However, the preemption right remains in effect, and the grantor cannot sell to a third party in breach of that right. Next page. Study notes formalities and remedies for breach of preemption agreements. Underscore. 2.5. 2.7 Formalities. Hershowitz v. Mullman, preemption agreements had to comply with the same formalities as the main agreement. For land sales, this meant compliance with S21 of the Alienation of Land Act. Mokorne v. Tassos Properties CC, Constitutional Court decision. A preemption agreement does not need to comply with formalities. However, any sale resulting from the exercise of the preemptive right must be in writing and signed. The grantee can enforce their right by submitting a signed offer and compelling the grantor to countersign. If the grantor refuses, an official, such as a registrar, can be ordered to countersign the offer. Underscore. 2.5. 2.8 Remedies for breach. Scenario: grantor A. grants a preemption right to grantee, B. but sells the property to a third party, C. without first offering it to B. Material breach: B can choose to cancel or uphold the preemption agreement. If B cancels, the agreement is terminated. B is entitled to restitution of any amount paid for the preemption right. B can claim damages for lost profits if B would have accepted the offer if A had made it. The sale would have been profitable for B. If B intended to sell the preemption right, damages may be claimed for the lost profit on that transaction. If B upholds the contract, specific performance of the negative obligation, not to sell to C, is available. B can get an interdict restraining A from selling or transferring the property. Uncertainty over specific performance of the positive obligation. Courts hesitate to order the grantor to make an offer to B. Oceanic v. African Consolidated Theatres, Proprietary, Limited. Bota and Potgieter JJA. No specific performance of the positive obligation. Ogle v. Thompson J. The grantor should be compelled to make an offer. Later courts assumed, but did not decide, that specific performance could be ordered. Associated South African Bakeries, Proprietary, Limited v. Oryx and Verenigde Bäckereien, Proprietary, Limited. New doctrine, Oryx mechanism, developed instead of ordinary specific performance rules. If A sells to C in breach of the preemption agreement, B can step into the shoes of C by making a unilateral declaration to A. This creates a new contract of sale between A and B on the same terms as A and C's agreement. Effect: B's sale is prioritized over C's due to the first-in-time, first-in-law principle. If transfer to C has not yet occurred, B is entitled to transfer of the property. If C has already taken transfer, B can only claim damages, unless C was not a bona fide purchaser. Unresolved issues left open in Oryx. 1. Does B need to wait until A actually sells to C, or does a mere offer to C suffice? 2. Can B use the Oryx mechanism if the sale must comply with formalities, for example, land sales? 3. Can B recover the property from C if C was unaware of B's preemption right at the time of the sale, but learned about it before transfer? Tiki Dry A and Dom, Proprietary, Limited v. Shell South Africa Marketing, Proprietary, Limited Constitutional Court. The court refused to hear an appeal that could have clarified these issues. Reason: the issues were of general public importance, but had not been properly raised in the lower courts. Next page. Study notes: difficulties with the Oryx mechanism. _ 1. The court's preference for the Oryx mechanism. Courts have avoided applying ordinary principles of specific performance to preemption agreements. Instead, they introduced the Oryx mechanism, which allows the grantee, B, to unilaterally declare a sale with the grantor, A, without court intervention. This mechanism allows B to enforce a sale rather than just the preemption right, bypassing the need for a court order. _ 2. Issues with contract law principles. The Oryx mechanism conflicts with the principle of consensuality in contracts, since B creates a contract by a unilateral declaration. Possible legal justifications for treating as offer to C as an offer to B. 1. As offer to C is deemed to be a tacit offer to B on identical terms. 2. A is deemed in law to have made an offer to B, a legal fiction, which is unsatisfactory. 3. The preemption agreement is seen as a conditional option, where the offer to B is triggered by the sale to C. Problems with the conditional option argument. If the preemption agreement is a conditional option, then B's acceptance by unilateral declaration must be on pre-agreed terms, rather than on the terms A agreed with C. If A and B did not pre-agree on sale terms, B's offer only becomes clear when A sells to C, creating uncertainty. _ 3. Practical limitations of the Oryx mechanism. Matching C's offer. If C's offer includes non-monetary terms, for example, part payment in shares of a private company, can B substitute this with cash? Some support exists for the idea that B can substitute a cash payment for non-monetary terms. However, existing case law suggests B must fully match the terms to step into C's shoes. Formal requirements for land sales. Alienation of Land Act requires a sale of land to be in writing and signed by both parties. If both the preemption agreement and as offered to C are in writing, will B's unilateral declaration in writing suffice? Van Rensburg's view. The preemption agreement, as offered to C, and B's declaration can be read together to satisfy formal requirements. Mokone v. Tassos Properties CC. The Constitutional Court confirmed the Oryx mechanism is valid for land sales. If A refuses to comply with formal requirements, a court can compel A to do so. Next page. Study notes: Mistaken Contract Law, Chapter 3 _ 3.1 Introduction. Mistaken contract law refers to an error regarding the terms, subject matter, or identity of the contracting parties. The impact of mistake depends on whether it prevents consensus and whether it is material or non-material. _ 3.2 Classification of mistake. 3.2.1 Unilateral, mutual, and common mistake. Unilateral mistake: one party is mistaken, and the other knows or ought to know about the mistake. Mutual mistake: both parties misunderstand each other, but their misunderstandings differ. Common mistake: both parties share the same mistaken belief about a fundamental aspect of the contract. _ 3.2.2 Irrelevant and relevant mistake. Irrelevant mistake does not affect consensus and does not void the contract. Relevant mistake affects consensus and may void the contract if material. _ 3.2.3 Material and non-material mistake. 3.2.3 Non-material mistake. A mistake is material if it prevents true agreement, consensus ad idem. Types of material mistakes. Error in negotiation, mistake about the nature of the contract. Error in corpore, mistake about the subject matter. Error in persona, mistake about the identity of the contracting party, only material if identity is crucial. Error in substantia, mistake about the essential qualities of the subject matter. 3.2.3 Non-material mistake. A mistake is non-material if it does not affect consensus or only concerns minor details. _. 3.2.4 Traditional classification of material and non-material mistake. Traditional distinction focuses on whether the mistake affects the essential elements of consensus. Courts typically require a material mistake to void a contract. _. 3.2.5 Mistake of law and mistake of fact. Mistake of law, a misunderstanding of the legal consequences of the contract. Mistake of fact, a misunderstanding of the facts relevant to the contract. _. 3.3 Limitations of the will theory. The will theory states that contracts are based on the actual intention of the parties. Courts do not always adhere strictly to this theory, as reliance-based correctives are needed. _. 3.4 Reliance-based correctives. Courts sometimes override subjective intention in favor of what the parties represented to each other, protects good faith and contractual fairness. _. 3.5 The subjective approach as qualified by estoppel and quasi-mutual assent. 3.5.1 The doctrine of estoppel. A party is prevented, estopped, from denying their previous representation if they made a misrepresentation. The other party relied on it to their detriment. 3.5.2 The doctrine of quasi-mutual assent. Direct reliance theory. A party may be bound by a contract despite their actual intention, if they reasonably appeared to agree to the terms. The other party relied on this appearance of agreement. _. 3.6 The objective approach as qualified by the use error doctrine. 3.6.1 The declaration theory in case law. Contracts are based on external expressions, declarations of intention, not internal intention. 3.6 Do the use error doctrine. A party may escape a contract if their mistake was reasonable. Use error. Courts assess whether the mistake was induced by the other party, reasonable in the circumstances. _. 3.7 Reconciliation of the subjective and objective approaches. 3.7.1 Sonap Petroleum, S.A., Proprietary, Limited v. Papadogiannis. Affirmed the reliance theory. A contract is formed if one party reasonably relied on the other's representation of agreement. 3.7 To Slipknot Investments 777, Proprietary, Limited v. Du Toit. Reinforce that a party cannot escape a contract due to a unilateral mistake unless the mistake was reasonable. 3.7.3 Direct or indirect reliance. Courts analyze whether a party directly relied on the representation, or if the reliance was implied from conduct. _. 3.8 Common mistake. A common mistake does not necessarily void a contract unless it relates to an essential fact that both parties assume to be true. _. 3.9 Rectification. If a written contract does not reflect the true agreement, courts may order rectification to correct the mistake. Requirements for rectification. A prior valid agreement existed. The written contract deviates from the actual agreement due to a mistake. Clear evidence of the true agreement. _. These study notes summarize the classification, legal treatment, and case law on mistake in contract law, focusing on materiality, reliance principles, and judicial approaches. Next page. Study notes Mistake in Contract Law, Chapter 3.1 to 3.2.3 3.1 Introduction. Contractual liability in South African law is based on will theory, requires actual, subjective agreement between the parties. Reliance theory, a contract may still arise if one party led the other to reasonably believe there was consensus. Courts apply reliance theory in different forms to resolve disputes arising from mistakes in contracts. Mistake in contract law occurs when a party acts under a misconception about a fact relevant to the contract. Key distinction. Mistake that destroys consent, prevents consensus ad idem and may render the contract void. Mistake that does not affect consensus, may render the contract voidable, rescindable. If the parties are aware of their disagreement, they may resolve it before concluding the contract. If one or both parties are unaware of the dissensus, it results in mistake, which is the focus of this chapter. 3.2 Classification of mistake. Mistakes in contracts are classified based on their impact on consensus and legal consequences. Understanding these distinctions helps in determining contractual liability. 3.2.1 Unilateral, mutual, and common mistake. Unilateral mistake. Definition: one party is mistaken about a key fact, and the other party knows or ought to know about the mistake. Example: A mistakes the price of a contract, but B knows of the mistake and remains silent. B is aware of his misunderstanding but does not correct it. Legal consequence: the contract may be void if the mistake is material and reliance theory does not apply. Mutual mistake. Definition: both parties are mistaken about each other's intentions, leading to dissensus. Example: A intends to buy house X, while B thinks they are selling house Y. Both are unaware of the misunderstanding. Legal consequence: the contract is void due to the lack of consensus ad idem. Common mistake. Definition: both parties share the same mistaken belief about an essential fact. Key difference: unlike unilateral and mutual mistakes, there is consensus, but it is based on a false assumption. Example: A and B contract to sell a painting, believing it is an original, but later discover it is a fake. Legal consequence: the contract is void, as it is based on a fundamental mistaken assumption. Summary of mistake classifications. Type of mistake: nature of mistake, consensus, legal consequence. Common mistake: both parties share the same incorrect belief, white tick mark emoji, consensus, but incorrect assumption, contract is void. Mutual mistake: both parties misunderstand each other's intention, cross mark emoji, dissensus, contract is void. Unilateral mistake: one party is mistaken, and the other party knows or should know, cross mark emoji, dissensus, contract may be void, depending on reliance principles. 3.2.2 Irrelevant and relevant mistake. Irrelevant mistake. Definition: a mistake that does not affect consensus and does not influence the party's decision to enter into the contract. Example: a mistakenly believes the contract includes an additional benefit, but would have signed the contract anyway. Legal consequence: the contract remains valid and binding. Relevant mistake. Definition: a mistake that affects consensus, making the contract void or voidable. Example: assigns a contract believing it is for a loan, but it is actually a suretyship, Khan v. Naidu. Legal consequence: if the mistake destroys consent, the contract is void. If induced by misrepresentation, the contract is voidable. 3.2.3 Material and non-material mistake. Material mistake. Definition: a mistake that negates actual consensus, meaning the parties were never truly in agreement. Legal consequence: the contract is void ab initio, from the beginning, if no consensus was reached. Courts may apply reliance theory to determine if the mistaken party is still bound. Types of material mistakes. Error in negotiation, mistake about the nature of the contract, for example, believing it is a lease instead of a sale. Error in corpore, mistake about the subject matter, for example, buying the wrong item. Error in persona, mistake about the identity of the other party, only material if identity is essential. Error in substantia, mistake about the essential qualities of the subject matter. Non-material mistake. Definition: a mistake that does not affect actual agreement, but may arise from misrepresentation, duress, or undue influence. Legal consequence: the contract remains valid, but may be voidable if entered into under improper circumstances. Distinction between material and non-material mistake. Type of mistake: effect on consensus, legal consequence. Material mistake prevents true agreement, consensus ad idem, contract is void, unless reliance theory applies. Non-material mistake: agreement exists, but obtained under improper circumstances, contract is valid but voidable, if induced by misrepresentation, duress, etc. Key takeaways. Mistakes in contract law impact whether a valid contract exists. Unilateral, mutual, and common mistakes are distinguished based on whether the parties misunderstand each other or share the same mistaken assumption. Irrelevant mistakes do not affect contractual liability, whereas relevant mistakes may lead to the contract being void or voidable. Material mistakes negate consensus and may render a contract void ab initio, while non-material mistakes do not negate consensus but may result in rescission. Courts use reliance-based correctives to determine contractual liability where actual consensus is absent. This summary provides a structured and detailed breakdown of mistake in contract law, focusing on key distinctions, classifications, and legal consequences. Let me know if you need further clarification or case law analysis. Next page. Confusing aspects of the inducement requirement for a relevant mistake. Khan v. Naidu established that a relevant mistake must act as an inducement to contract, meaning it must influence the mistaken party's decision. Issue of confusion. Inducement is also a requirement for an actionable misrepresentation, which determines whether a misrepresentation is material. This overlap creates uncertainty in how inducement applies to mistake. Proposed solution. Inducement should be confined to non-material mistakes, meaning it should apply only where consensus exists but the contract is potentially voidable. For material mistakes, courts should focus on whether the mistake vitiates actual consent rather than whether it induced the contract. Reinterpretation of Khan v. Naidu. If inducement were not a factor, the mistake in Khan v. Naidu could be classified as material, meaning there was no true agreement rather than merely a voidable contract. This distinction is crucial in determining when a contract is void, lack of consensus, versus voidable, consensus obtained improperly. Next page, Chapter 3, Mistake in Contract Law 3.1 Introduction. Contractual liability in South African law is based on will theory, subjective agreement. Reliance theory, objective criteria where one party reasonably believes consensus exists. This chapter focuses on contracts lacking subjective agreement due to material mistakes that prevent consensus ad idem. Mistake in contract occurs when a party acts under a misconception about a fact affecting the contract. A distinction is made between mistakes that vitiate consent, potentially void contracts. Mistakes that do not vitiate consent, potentially voidable contracts. Mistakes causing dissensus and awareness of disagreement are the focus of this chapter. 3.2 Classification of mistake. Contractual mistakes are categorized based on their impact on agreement and enforceability. 3.2.1 Unilateral, mutual, and common mistake. Unilateral mistake, one party is mistaken, the other is aware but remains silent. Mutual mistake, both parties misunderstand each other's intentions. Results in dissensus, no contract. Common mistake, both parties share the same erroneous assumption. Does not lead to dissensus but renders the contract void if the assumption is fundamental. Table 3.1 Types of mistake. Type of mistake. Description. Effect. Common mistake. A and B share the same false assumption. Void contract. Mutual mistake. A and B misunderstand each other's intent. Cross purposes. Dissensus, no contract. Unilateral mistake. A is mistaken, B knows but remains silent. Dissensus, no contract. 3.2.2 Irrelevant and relevant mistake. Irrelevant mistake does not affect consensus, the contract remains valid. Example, a mistake that does not influence the mistaken party's decision to contract. Relevant mistake affects the decision to contract and may cause dissensus. Example, a party signs a contract believing it relates to something entirely different. Khan v. Naidu, suretyship signed under a false impression. The court enforced the contract because the mistake did not affect the party's decision. The mistake must induce the contract to be relevant. 3.2.3 Material and non-material mistake. Material mistake vitiates consensus, leads to dissensus, contract void. Mistakes about identity, terms, or consequences of a contract are material. Non-material mistake does not negate consensus but may render the contract voidable due to misrepresentation, duress, undue influence, etc., the contract remains valid unless rescinded. Confusion in the inducement requirement. Convene to issue. Inducement is required for both. 1. Determining a relevant mistake must influence decision to contract. 2. Determining a material misrepresentation must have induced agreement. Proposed distinction. Inducement should apply only to non-material mistakes, where consensus exists but is improperly obtained. Material mistake should be assessed solely on whether it vitiates actual consent. _ 3.2.3.1 Material mistake. Elements of consensus. From Chapter 1, a valid contract requires 1. Serious intention to contract, animus comprehendi. 2. Agreement on material aspects, terms and parties. 3. Consciousness of agreement, awareness of mutual intention. If a mistake negates any of these, it is material and leads to dissensus. Examples of material mistakes. 1. Lack of serious intention to contract. A party does not intend to be legally bound. Examples: jest or social agreements, gentlemen's agreements. Mundop eendamsagentskap v. Kemp and de Beer, the appellant's representative signed a document without intending to incur legal liability. Held, no contract was formed. 2. Mistake regarding material aspects of the contract. Mistake about the identity of a party is usually material. Example: a mistakenly accepts an offer intended for someone else. Material mistake, no consensus. Mistake about the subject matter. Allen v. 16 Sterling Investments. The buyer thought he was purchasing one property, but the contract referred to another. Held, no agreement on the subject matter. Material mistake, no contract. Mistake about contractual terms or legal consequences. If a party misunderstands a key contractual term, the mistake is material. Example: a director signs a credit application unaware, includes a suretyship clause. Material mistake, void contract. Unilateral contract variation clauses. If a party is unaware that the contract allows unilateral changes to performance or liability, the mistake is material. 3. Lack of consciousness of agreement. Both parties must be aware of each other's intent. Bloom v. American Swiss Watch Company. A company offered a reward for information on stolen jewelry. The claimant gave the information before knowing about the reward. Held, no consensus, no contract. _ 3.3 Limitations of the will theory. The will theory assumes contracts are valid only when actual consensus exists. However, strict adherence creates unfair outcomes, as a mistaken party could easily escape liability. Courts apply reliance-based principles to correct the harshness of the will theory. _ 3.4 Reliance-based correctives. Courts use objective reliance criteria to bind a mistaken party if the other party reasonably believed consensus existed. _ 3.5 Subjective approach. Qualified by estoppel and quasi-mutual assent. 3.5.1 Doctrine of estoppel. A party may be prevented from denying a contract if their conduct misled the other party into believing a contract existed. 3.5.2 Quasi-mutual assent. Direct reliance theory. If a party leads another to reasonably believe consensus exists, the mistaken party may still be bound. _ 3.6 Objective approach and the use error doctrine. 3.6.1 Declaration theory. In case law, courts sometimes disregard the actual will of the parties and focus on outward manifestations of agreement. 3.6.2 Use error doctrine. If a mistaken party's belief was reasonable, they may escape liability, even if the other party relied on their outward conduct. _ 3.7 Reconciling subjective and objective approaches. Key cases: Sonap, Petroleum v. Papadogiannis, established reliance-based principles to determine contractual liability. Slipknot Investments v. Dutoit, addressed whether reliance was direct or indirect in mistake cases. _ 3.8 Common mistake. Unlike mutual and unilateral mistake, a common mistake does not cause dissensus but still invalidates the contract. _ 3.9 Rectification. If a contract does not reflect the true agreement due to a mistake, a court may rectify it to reflect the party's true intent. _ Conclusion. Mistake in contract law is complex, requiring courts to balance 1. Will theory, actual consensus. 2. Reliance theory, reasonable belief in consensus. 3. Corrective doctrines like estoppel and use error to prevent unfair outcomes. Next. Page 3.2. Non-material mistake. Definition: a non-material mistake influences a party's decision to enter into a contract, but does not affect consensus. The parties are still at idem, of one mind, on the material aspects of the contract. Typically an error in motive, mistake about why a party entered into the contract. Key case: Diedrichs v. Minister of Lands. Facts: the defendant offered to purchase land from the plaintiff. However, the defendant could have repossessed the land at a cheaper price under an existing lease. The defendant later refused to honor the contract, claiming a clerical mistake. Court holding: the mistake related to the defendant's motive for making the offer. Consensus was present, so a valid contract existed. Principle: a mistake about motive does not invalidate consensus. Contract is valid. Legal recourse for non-material mistake: if the mistake was induced by misrepresentation, the mistaken party may have a remedy. The requirements for misrepresentation must be met. _. 3.2.4 Traditional classification of mistake. Historically, mistakes are categorized by type. The materiality of a mistake is determined by the type of mistake. The same principles apply but are classified according to common mistake types. 4 Traditional types of mistakes. 1. Error in corpore, mistake about the subject matter. Definition: a material mistake concerning the object of the performance, for example, property, goods. Effect: vitiates consent. Contract void due to dissensus. Key case: Moreski v. Morkel. Facts: the respondent thought he was purchasing property at Site A due to a newspaper ad. The actual contract was for Site B. Court holding: the mistake was in corpore, vitiating consent. No valid contract arose. 2. Error in negotio, mistake about the nature of the contract. Definition: a mistake about the true nature of the juristic act, for example, sale versus donation. Effect: typically material, causing dissensus. Key case: Khan v. Naidu. Facts: the appellant, an illiterate woman, signed a document believing it transferred property to her. The document actually made her a surety for her son's debt. Court holding: the appellant did not understand the true nature of the contract. No consensus. The mistake was material, leading to a void contract. 3. Error in persona, mistake about the identity of the other party. Definition: a mistake about who the contract is with. Effect: usually material, but only if the mistaken party regards identity as crucial. Key case: Cork v. Osborne. Facts: the defendant believed he was selling property to 2 buyers jointly. The contract was actually only with one of them. Court holding: the mistake was about the identity of the contracting party. No consensus. Contract void. Further distinctions in error in persona. Gibert view: a mistake about the identity of the party is always material. A mistake about the party's name or attribute is not material. Conclusion: material mistakes invalidate consensus and void the contract. Non-material mistakes do not affect consensus, so the contract remains valid. The traditional classification categorizes material mistakes by subject matter, contract type, or party identity. Next. Page 4. Error in substantia, error in qualitate. Definition: a mistake about an attribute or characteristic of the subject matter, object of performance. Traditionally not regarded as material in South African law. Effect: usually non-material and classified as an error in motive, does not affect consensus. Key case: Trollope v. Jordan. Facts: the appellant bought a farm under a deed of sale correctly reflecting its boundaries and size. However, the seller's agent misrepresented the amount of afforested land included. Court holding: The mistake was not incorporeal, not about the identity of the land. Since both parties had the same land in mind, the mistake was non-material. Legal principle. If parties agree on the same object of performance, an error in substantia is not material. Exception. Spenmac, Proprietary, Limited v. Tatram CC. Facts. The seller misrepresented that Unit 1 in a sectional title scheme was one of only 2 units. The buyer later discovered that Unit 2 had been subdivided into 110 units. The agreement included a non-reliance clause, but the buyer successfully applied to void the contract. Supreme Court of Appeal holding. The misrepresentation was innocent but led to a fundamental mistake about the subject matter, Merckx. The court held that the mistake was material, making the contract void from the outset. Legal issue. The mistake was not incorporeal. The buyer still bought Unit 1, but in qualitate, about the rights attached to Unit 1. The ruling suggests error in substantia may sometimes be material, creating uncertainty in the law. Unresolved question. Did the court introduce a doctrine of material error in substantia, or did it misapply the law? Significance of the traditional classifications. The traditional classifications are not exhaustive. They help distinguish between material and non-material mistakes. The real focus should be whether the mistake affects the content of the obligation, operative mistake, or is merely a mistake in motive, non-operative mistake. Clarification needed. Error in persona should always be material if identity is crucial for consensus. Next. Page 3.2.5 Mistake of law and mistake of fact. Distinction. Mistake of fact, error facti, incorrect understanding of facts relevant to the contract. Mistake of law, error juris, incorrect understanding of the law applicable to the contract. The highest courts have not definitively ruled on the impact of mistake of law in contract law. Common law approach. Roman and Roman Dutch law required a factual mistake, error facti, for certain enrichment claims, for example, condictio in debiti. Courts historically treated mistakes of law as not a valid defense in contract disputes. Key cases. 1. Kimberley Share Exchange Company v. Hampson. The court held that mistake of law was not a valid legal defense for avoiding a contract. 2. Van Aertsen v. Van Aertsen. The court ruled that a mistake of law that relates to motive does not affect consensus contract remains valid. Correct approach to mistake of law versus mistake of fact. The key question is whether the mistake only affected the motive for the contract. If the mistake only relates to motive not material, if the mistake affects consensus material mistake, the classification as mistake of fact or law is secondary to the impact on consensus. Table 3.2 Materiality of mistakes. Type of mistake definition material. Error in corpore mistake as to the subject matter of the contract material. Error in negotiable mistake as to the nature of the contract material. Error in persona mistake as to the identity of the contracting party sometimes material. Error in substantia/qualitative mistake about attributes of the subject matter not material. Error in motive mistake as to why a party entered into the contract not material. Error juris mistake about the law governing the contract material only if it relates to the terms of the agreement, not motive. Next. Page 3.3 Limitations of the will theory. Unqualified application. If consensus is absent, a contract cannot arise. Any material mistake would invalidate the contract. A party could manipulate the will theory to avoid contractual liability by alleging a mistake. Reservatio mentalis. A party appears to consent but secretly does not intend to be bound. A strict will theory application would support such deception. This could lead to fraud and perjury. Impact on fairness and contract reliability. If dissensus is not apparent, a party relying on the contract could suffer financial loss. Uncertainty could undermine confidence in contractual commitments. South African law does not apply the will theory strictly. A qualified subjective approach is followed. The objective approach is introduced via reliance-based correctives. 3.4 Reliance-based correctives. Courts fluctuate between subjective, will theory, and objective, reliance theory, approaches. The subjective approach is qualified by 1. Estoppel prevents a party from denying apparent agreement. 2. Quasi-mutual assent, direct reliance theory, binds a party if reasonable reliance is established. 3. Use error doctrine corrects an extreme objective approach, declaration theory. Intersection between subjective and objective approaches. Reliance serves as a bridge between the two. Primary approach equals subjective, consensus-based. Secondary approach equals reliance-based liability when consensus is unclear. 3.5 Subjective approach qualified by estoppel and quasi-mutual assent. Blackburn J's principle, Smith v. Hughes case. If a party acts in a way that suggests consent, and the other party relies on it, they are bound. If a reasonable person would believe agreement was reached, a contract exists, even if there was no actual consensus. South African reception of the principle. Courts use objective correctives when dissensus arises. Doctrinal debate. Some argue that quasi-mutual assent derives from estoppel. Others maintain that quasi-mutual assent is a separate reliance-based doctrine. Distinction between estoppel and quasi-mutual assent. Doctrine effect key feature. Estoppel prevents denial of a contract, fictional contract, based on representations and reliance. Quasi-mutual assent creates an actual contract based on reasonable reliance. Common ground. Both doctrines protect reasonable expectations. Both limit the strict will theory. Often lead to similar outcomes. Key distinction. Estoppel creates a fictional contract. Quasi-mutual assent results in a real contract. Next. Page 3.5.1 The Doctrine of Estoppel. Introduction to Estoppel. Origin, derived from English law. Basic principle. If Party A, estoppel denier, misrepresents a fact to Party B, estoppel raiser, and B reasonably relies on it to their detriment, A cannot later deny the misrepresentation. A successful estoppel plea means the court treats the misrepresentation as true between the parties. Example. A tells B something false, B relies on it, and later A denies the misrepresentation. The court prevents A from contradicting the original statement to protect B from prejudice. Case law on estoppel. Forden v. Lelleveld. Facts. The owner of a racehorse leased it to B&L, but disguised the agreement as a sale to evade Jockey Club regulations. B&L later sold the horse to the defendant. The true owner claimed the horse using the re vindicatio. Court's decision. The defendant successfully raised estoppel. The owner enabled B&L to appear as owners by issuing a false receipt. The court upheld the fiction that B&L were the owners. Van Ryn Wine and Spirit Company v. Chandos Bar. Facts. The appellant's agent falsely promised a discount on liquor if cash was paid. The respondent paid the agent, but the appellant never received the money. The appellant claimed payment, arguing quasi-mutual assent, as the respondent did not challenge the invoices. Court's decision. The court rejected the appellant's claim. While estoppel could apply in principle, the respondent's reliance on the agent's misrepresentation was reasonable. The court accepted that estoppel could be used to enforce an apparent contract, even if actual consensus was absent. Limitations of estoppel. 1. High burden of proof. The estoppel raiser must prove a misrepresentation was made. A reasonable inference of agreement existed. Prejudice resulted from reliance on the misrepresentation. 2. Prejudice requirement. Courts caution against loosening the requirement of prejudice. Simply entering a contract based on a misrepresentation may not always be enough. 3. Fault uncertainty. Textbooks suggest that estoppel requires intention or negligence. However, courts have not definitively settled this point. 4. Estoppel creates a fictional contract. Unlike quasi-mutual assent, estoppel does not create a real contract. The fictional nature of the contract means contractual rights cannot be ceded to third parties. Only the estoppel raiser is protected. 5. Limited role in dissensus cases. While estoppel could apply to cases of dissensus, courts prefer quasi-mutual assent, which creates a real contract rather than a fictional one. Next. Page 3.5.2 The Doctrine of Quasi-Mutual Assent, Direct Reliance Theory Overview. Distinction from estoppel. Unlike estoppel, quasi-mutual assent results in a real contract, not a fictional one. Based on reasonable reliance on the appearance of agreement, the contract asserter must reasonably believe that the contract denier agreed to the terms. Case law on quasi-mutual assent. Peters & Co. v. Salomon. Facts. Plaintiffs offered to pay a debt of £345 for burger, but mistakenly thought this was the full amount. Actual debt equals £490. The defendant accepted the payment without knowing about the mistake. Plaintiffs later argued they never intended to pay more than £345. Court's decision. The plaintiff's unexpressed intention to pay only £345 was irrelevant. The defendant was entitled to the full £490 because the plaintiff's conduct reasonably led him to believe they were paying the entire amount. Hodgson Brothers v. South African Railways. Facts. Plaintiffs offered to sell a lorry for £500. Defendant agreed to purchase it, but later tried to change the price to £300. Plaintiffs insisted the contract was for £500. Court's decision. Defendant created a reasonable belief that they had agreed to £500. Since the defendant had induced this belief, they were bound to it, regardless of their actual intention. Elements of quasi-mutual assent. 1. Inducement by contract denier. The contract denier must have induced the belief that an agreement existed. If the contract asserter reasonably believed consensus was reached, a contract exists. 2. Reasonableness of reliance. The reliance must be reasonable under the circumstances. If a reasonable person would have noticed a mistake or lack of agreement, reliance is not justified. Application in Redon v. Van der Spey and Partners, Westcop, Incorporated. Facts. Plaintiff was to receive a $358,000 from a farm sale. Defendant, law firm, issued a written undertaking to pay upon transfer. Later, the defendant's client refused payment, citing possible claims for set-off. Plaintiff only received a partial payment and sued for the balance. Court's decision. Defendant's written undertaking created a reasonable expectation of personal liability. Plaintiff relied on the undertaking and committed financially based on it. Court upheld the plaintiff's claim, confirming the defendant was personally liable for the full amount. Key differences between estoppel and quasi-mutual assent. Aspect estoppel quasi-mutual assent. Nature of contract fictional real. Requirement prevents denying a representation enforces a contract based on reliance. Protection only for estoppel raiser creates contractual rights. Role of intention irrelevant contract denier's conduct must induce reliance. Quasi-mutual assent creates an enforceable contract, whereas estoppel only prevents a party from denying a misrepresentation. Next. Page. Fault and prejudice in quasi-mutual assent. Uncertainty regarding fault and prejudice. No clear guidance from the Supreme Court of Appeal on whether fault and prejudice are necessary for quasi-mutual assent. Fault, intention or negligence is not explicitly required, as courts often apply the reliance theory without mentioning fault. Prejudice, harm suffered by the contract asserter, is also uncertain as a strict requirement. The prevailing view, what matters is whether the reliance was reasonable in the circumstances. _ Onus of proof in quasi-mutual assent. The contract assertor bears the burden of proof on a balance of probabilities. Must prove 1. Facts indicating apparent agreement despite dissensus. 2. Reasonable reliance on consensus. If proven, quasi-mutual assent applies, binding the contract denier. Caveat subscripta and quasi-mutual assent. Caveat subscripta: a person who signs a contract is bound by it, as their signature creates an impression of agreement. Quasi-mutual assent underpins this principle, shifting the onus to the contract denier to rebut a prima facie inference of reasonable reliance. If the facts suggest no ostensible agreement, lack of reasonable reliance, the contract assertor may fail to discharge the burden of proof. Duty to inform of unusual terms. General rule: a contractual party is not obligated to inform the other party of the contract's terms. Exception: if the contract contains unexpected or unusual terms, the enforcing party must inform the other party. Failure to do so reliance on consensus is not reasonable. Effect: the contract may be unenforceable against the uninformed party. Next page. The objective approach and the use error doctrine. The declaration theory, wholly objective approach, contractual liability is based on external declarations of will rather than actual intention. Subjective intention is irrelevant, only outward manifestations of agreement matter. Controversy: a contract could be imposed even if neither party truly intended it. The use error doctrine serves as a qualification to prevent unjust outcomes. 3.6.1 The declaration theory in case law. South African Railways and Harbours v National Bank of South Africa Limited. Key dictum by Wessels J. The law does not examine the inner thoughts of the parties but focuses on external expressions. If parties appear to agree, the law assumes contractual consensus unless fraud is involved. Effect: courts focus on objective declarations rather than actual agreement. Interpretation: courts do not strictly apply the declaration theory. Instead, they use it to find actual intention within declarations. This approach continues to influence the Supreme Court of Appeal. Modified objective approach in case law. Courts do not fully apply the declaration theory, but combine it with the use error doctrine. Effect: a contract based on objective agreement can be set aside if a material and reasonable mistake occurred. Key case: National and Overseas Distributors Corporation, Proprietary, Limited v. Potato Board. Facts: respondent invited tenders for a steel shed. Appellant's tender was accepted by letter, but later repudiated due to an administrative error. Appellant sued for damages, arguing a valid contract had been formed. Decision: the appellate division upheld the appeal. Once acceptance was communicated, a contract was formed, even if sent in error. Mistake was not raised as a defense, and the error was not reasonable. A natural person in a similar situation could not escape liability due to a mistaken letter. Key principle: reinforces an objective approach. Contract formation depends on outward manifestations. The respondent's manager was legally capable of binding the organization despite internal miscommunication. Criticism and influence of the objective approach. Criticism: the Potato Board case has been viewed as applying a rigid declaration theory. However, the decision remains influential, and the Supreme Court of Appeal continues to cite it. A generally objective approach is evident in various cases. Legal writers acknowledge that case law sometimes reflects an objective approach to contract formation. Next page. 3.6. Do the use error doctrine. Origin and purpose. The use error doctrine originally stemmed from a text on restitutio in integrum for reasonable error. Although its application to contractual mistake is debatable, courts have used it for contract law since the late 19th century. Now firmly established in South African law, it serves as a corrective measure in cases of dissensus. Key function. A party will not be bound if their apparent consent was given by mistake, and the mistake is both material and reasonable use. If ostensible agreement exists, the contract denier bears the onus to prove their mistake was both material, reasonable, use. If successful, the contract is void ab initio. Otherwise, the contract remains binding. Determining a reasonable, use mistake. A mistake is reasonable, use based on objective circumstances. There is no comprehensive test. Guidelines have developed through case law. Key dicta on use error. 1. George v. Fairmead, Proprietary, Limited, Fagan C.J. Courts consider the position of both parties when assessing justice error. Key question. Did the contract denier's conduct lead the other party to reasonably believe they were agreeing? Effect. If the mistake is caused by a misrepresentation, innocent or fraudulent, the contract denier is not bound. If the contract denier is at fault, they remain bound. 2. National and Overseas Distributors Corporation, Proprietary, Limited v. Potato Board, Shriner J. A party may use their own mistake as a defense in some cases. However, if the other party did not misrepresent anything and did not realize a mistake was being made, then unilateral mistake as a defense is very limited. Key requirement. The mistake must be pleaded and must be use reasonable. Criteria for a reasonable, use mistake. 1. Mistake induced by misrepresentation. A material mistake is usually reasonable if caused by a misrepresentation from the contract asserter or their legal representative. For a representation to justify a mistake, it must be legally unacceptable, considered wrongful, or contra bonos mores. Types of misrepresentation. Positive misrepresentation, false statement, negative misrepresentation, omission of crucial facts. Case, Allen v. 16 Sterling Investments, Proprietary, Limited. Facts. The plaintiff was misled by the defendant's agent, who pointed out the wrong property. The plaintiff signed the deed believing he was purchasing a different property. Decision. The plaintiff's mistake was reasonable because it was induced by the agent's misrepresentation. The contract was therefore void. Summary. The use error doctrine prevents unfair contractual liability in cases of material and reasonable mistakes. If a contract appears valid, the burden shifts to the contract denier to prove their mistake was use. Courts assess reasonableness based on case law, considering whether misrepresentation caused the mistake, whether the contract denier led the other party to believe in their consent. A mistake induced by a wrongful misrepresentation is almost always reasonable and can void the contract. Next page. Negative misrepresentation and the use error doctrine. Definition of negative misrepresentation. Occurs when a party remains silent despite a legal duty to disclose information to correct the other party's misunderstanding. Silence amounts to misrepresentation, by omission only if it is wrongful in the eyes of the law. A legal duty to speak arises in specific circumstances. Circumstances establishing a legal duty to speak. 1. Where the contract asserter knows or ought to know the other party is mistaken. If the contract asserter knows or reasonably should know that the contract denier is mistaken, they must correct the misunderstanding. Key principle: a party cannot snatch at a bargain knowing the other made a mistake. Case, Hartog v. Collin and Shields. Facts. Defendants mistakenly offered prices per pound instead of per piece for 30,000 skins. Plaintiffs accepted the incorrect offer, knowing it was a pricing error. Decision. Plaintiffs were not entitled to enforce the contract as they knew of the defendant's mistake. The court refused the claim for breach of contract. Case, Prince v. Absa Bank Limited. Facts. Appellant mistakenly believed he was signing a limited suretyship of R10,000. It was actually unlimited. The bank later sued for a much higher amount. Decision. The bank's own correspondence supported the appellant's belief. The bank should have clarified the misunderstanding. Failure to correct the error rendered the mistake useless, and the contract was unenforceable. 2. Where the contract assertor previously created a conflicting impression. If a party creates an impression conflicting with the contract's actual terms, they must disclose the discrepancy before finalizing the contract. Case, Dutoit v. Atkinson's Motors BPK. Facts. Respondent advertised a car as a Mercedes-Benz 350, 1979. Appellant relied on the advertisement and orally agreed to purchase. Later, the appellant signed a contract containing an exemption clause, stating the seller was not liable for misrepresentations about the car's year. The seller did not inform the appellant about this clause. Decision. The court held that the advertisement misled the buyer, and the seller's silence about the exemption clause amounted to misrepresentation. The mistake was reasonable, and the contract was rescinded. Principle. If a party relies on a specific impression created before the contract, the other party must disclose any contradictions in the contract. Failure to do so renders the contract voidable. Clarifications on the duty to speak. The Supreme Court of Appeal, SCA, ruled that a duty to speak does not automatically arise just because a term, for example, an exclusion clause, is expected in the contract. However, context matters. The existence of a duty depends on the nature of the contract and circumstances. Case, Brink v. Humphreys and Jewell, Proprietary, Limited. Facts. A personal suretyship was hidden in a credit application form. The appellant signed it without knowing about the suretyship. Decision. The court found the clause to be a trap for the unwary. The appellant was justifiably misled, making the contract unenforceable. Other considerations for a mistake to be used. Reasonable 1. Fault of the contract denier. If the contract denier acted reasonably and was not negligent, the mistake may be excusable. However, fault remains a contentious issue. Case, Slipknot Investments 777, Proprietary, Limited v. Dutoit. Key ruling. Even if the contract denier was without fault, they may still be held liable if their conduct led the contract asserter to reasonably believe they consented. Fault on the part of the contract denier weighs against finding the mistake used, but is not always conclusive. Example. Some cases involve negligence in not reading a contract, yet the court still ruled in favor of the contract denier. This occurs when the contract asserter lacked a reasonable belief in consensus. 2. No reasonable belief in consensus. If the contract asserter could not have reasonably believed that the contract denier assented to the agreement, the mistake is use. Modern law reconciles the use error approach with the reliance theory, meaning, if the asserter's reliance on consensus is unreasonable, the mistake will be excusable. Older cases contradicting this are no longer valid authority. Summary. Negative misrepresentation occurs when a party fails to disclose a misunderstanding despite a legal duty to do so. A duty to speak arises when the contract asserter knows, or ought to know, of the contract denier's mistake. The contract asserter previously created a conflicting impression. Key case law. Hartog v. Collin and Shields cannot take advantage of a clear mistake. Prince v. Absa Bank Limited failure to correct misunderstanding rendered mistake use. Dutoit v. Atkinson's Motors BPK advertised terms must match contract terms. Brink v. Humphreys and Jewell, Proprietary, Limited hidden suretyship clause was misleading. A mistake may be excusable if the contract denier was not at fault, but fault is not always decisive. If no reasonable belief in consensus exists, the mistake is use, making the contract void. Next page. Negative misrepresentation occurs when a party remains silent when they have a legal duty to speak to correct a misunderstanding. Silence can amount to misrepresentation by omission, when there is a legal obligation to disclose information. Instances where a legal duty to speak arises. 1. when the contract assertor knows or should know that the other party is mistaken. Hartog v. Collin and Shields, English case. Defendants mistakenly offered skins at a price per pound instead of per piece. Plaintiffs, knowing the mistake, accepted the offer. Court refused plaintiff's claim for breach of contract as they had snatched at a bargain knowing it was unintended. Prince v. Absa Bank Limited. Appellant mistakenly believed he signed a limited suretyship instead of an unlimited one. The bank's correspondence supported appellant's misunderstanding. Court found the bank ought to have been aware and corrected the mistake, making the appellant's error use juice. 2. When prior conduct creates a conflicting impression with the contract. Dutoit v. Atkinson's Motors BPK. Respondent advertised a Mercedes-Benz 350, 1979, but the car was actually a 1976 model. Appellant signed a contract with an exemption clause disclaiming misrepresentation liability. Court ruled that respondent misled the appellant by omission, making the appellant's mistake reasonable. Supreme Court of Appeal held that an exclusionary clause does not always trigger a duty to speak but depends on the contract and circumstances. Brink v. Humphreys and Jewell, Proprietary Limited. Hidden suretyship clause in a credit application form was ruled as misleading, a trap for the unwary. Excusability of a mistake. If the contract denier acted reasonably and without negligence, the mistake may be excusable. Slipknot Investments 777, Proprietary Limited v. Dutoit. Even if the contract denier is without fault, they may still be bound if their conduct reasonably led the other party to believe there was agreement. If the contract denier was at fault, for example, failing to read a document, this weakens their claim, but does not necessarily exclude excusability. When the contract denier's mistake is use juice. Error is use juice if the contract assertor's reliance on apparent consensus is unreasonable or non-existent. Recent case law suggests that all criteria for use juice error fall under the general principle that reliance must be reasonable. Reconciliation of subjective and objective approaches. Debate in South African law: is contractual liability primarily subjective, intention-based, or objective, reliance-based? Some scholars reject the declaration theory and the use juice error doctrine, preferring direct reliance theory. Courts have reconciled use juice error with quasi-mutual assent, treating use juice error as an indirect reliance theory application. Sonab Petroleum, S.A., Proprietary Limited v. Papadogiannis. Facts. A 20-year lease was mistakenly shortened to 15 years in an addendum. Respondent, knowing of the mistake, signed the addendum without correction. Court findings. Mistake was unilateral, only appellant's declared intention differed from actual intention. General rule: law looks at external manifestations, but dissensus cases require a reliance-based approach. If a party knows or should know of a possible mistake, they have a duty to speak before accepting an offer. Respondent failed to discharge this duty, therefore, no consensus existed. Addendum was declared void. Sonap reliance test determines if the contract denier misled the contract enforcer into a reasonable belief that there was consensus. 3-part inquiry. 1. Was there a misrepresentation of intent? 2. Who made the misrepresentation? 3. Was the other party misled? If yes, was it reasonable? If the contract enforcer knew or should have known of the mistake, they had a duty to inquire before accepting. Impact of SONAP on South African contract law. Established reliance theory as the primary approach in dissensus cases. Use juice error doctrine is merely an application of reliance theory. Smith v. Hughes confirmed as foundational case for quasi-mutual assent in South African law. Courts still allow parties to argue based on direct reliance, quasi-mutual assent, or indirect reliance, use juice error. Fault not required for the reliance test. Estoppel is not central to reliance-based mistake inquiries. Next. Page 3.7 Reconciliation of the subjective and objective approaches. The application of both subjective and objective approaches in material mistake cases raises issues regarding South African contract law's fundamental approach. Some scholars reject the declaration theory and its connection to the use error doctrine, advocating instead for the direct reliance theory. Others argue that the use error doctrine is a practical way to address material mistakes where ostensible agreement exists. A suggested reconciliation is to define use error in terms of quasi-mutual assent, making it an indirect application of reliance theory. South African courts have adopted this last approach. 3.7.1 Sonap Petroleum, S.A., Proprietary, Limited v. Papadogiannis. Facts. The parties entered a 20-year lease agreement. Due to an error, the appellant's attorney drafted an addendum shortening the lease to 15 years. The respondent, benefiting from the shorter term, signed without raising concerns. Quota quo, held the appellant's mistake was not use as it was due to its own fault. Appellate Division, Harms Asia, categorized the mistake as unilateral, only the appellant misunderstood its own intention. Confirmed that contract law generally focuses on external manifestations rather than internal intentions. Where dissensus exists, the reliance theory is used to determine contractual validity. Cited George v. Fairmead, Proprietary, Limited and National and Overseas Distributors Corporation, Proprietary, Limited v. Potato Board, linking use error to reliance theory. Reliance test, Sonap test, determines if the contract denier misled the contract enforcer into reasonably believing consensus existed. 3-part inquiry. 1. Was there a misrepresentation of intent? 2. Who made the misrepresentation? 3. Was the other party misled? If so, was the reliance reasonable? If the contract enforcer should have realized a mistake was possible, they had a duty to inquire before accepting the contract. Failure to inquire negates reasonable belief in consensus, making the mistake use. Judgment. The respondent was aware of a possible mistake but failed to inquire. No actual or imputed consent existed, so the addendum was void. Significance. The reliance theory is the primary approach to dissensus cases. The use error doctrine is an indirect application of the reliance theory. 3.7. To Slipknot Investments 777, Proprietary, Limited v. Du Toit. Facts. The respondent signed a deed of suretyship but claimed he did so under a mistake caused by a third party. He argued that he had no intention to incur liability. Court's approach, Malanja. Cited George v. Fairmead, Proprietary, Limited. A party is not bound if their mistake was induced by the other party's misrepresentation. However, in Slipknot, the mistake was induced by a third party, not the contract enforcer. Applied the Sonap reliance test. The respondent led the appellant to reasonably believe he had agreed to the suretyship. As a trustee, the respondent should have known the nature of the documents he signed. Judgment. The respondent was bound by the contract despite his mistake. Significance. Established that a mistake induced by a third party is irrelevant in reliance-based contract formation. Final reconciliation of use error and reliance theory. A contract denier's mistake is use if they did not induce the other party into reasonable belief of consensus. The presence or absence of misrepresentation determines which doctrine applies. 3.7.3 Direct or indirect reliance. The continued use of use error raises questions about whether an objective approach to contract law still applies. Some argue the declaration theory has been abandoned, while others suggest it should be explicitly overruled. Courts still use use error alongside an objective approach, but this is not conceptually problematic. Example: National and Overseas Distributors Corporation, Proprietary, Limited v. Potato Board. The respondent mistakenly accepted the appellant's offer. The court found a contract existed based on the declaration theory. However, this can also be justified using the quasi-mutual assent doctrine. The respondent led the appellant to reasonably believe consensus was reached. The same factors negating use error also confirmed reasonable reliance. Limitations and benefits of the use error approach. The doctrine applies where there is an ostensible agreement, for example, a signed contract. Where no apparent agreement exists, the contract enforcer must prove contractual liability through reasonable reliance. Benefits. In cases of dissensus, shifts focus from whether contractual liability exists to whether there are objective factors negating consensus. Balances security and certainty in market relations with fairness considerations. Preferred approach. Direct reliance theory is generally preferred. Use error is an alternative but functions as an indirect application of reliance theory. Conclusion. South African law primarily bases contractual liability on actual agreement. In cases of mistake, reliance-based principles, direct or indirect, determine liability. The reconciliation of these doctrines ensures both theoretical and practical consistency in contract law. Next page. 3.8 Common mistake. A common mistake differs from unilateral or mutual mistake as it does not lead to dissensus but still results in a void contract. Unlike other forms of mistake, a common mistake does not affect the intention of either party. Both are in complete agreement, consensus ad idem. The mistake concerns a fundamental underlying fact, a present or past assumption that turns out to be incorrect. Since there is no true disagreement, the use error doctrine and reliance theory do not apply. 3.8.1 Case law, Dickinson Motors, Proprietary, Limited v. Oberholzer. Facts. The plaintiff's son bought 2 cars on hire purchase. Car A from the defendant, car B from a third party. The son later disappeared, leaving unpaid debts on both vehicles. The defendant mistakenly attached car B, thinking it was car A, and obtained judgment against the son. The plaintiff, also under the mistaken belief that the attached car was car A, paid the outstanding debt to keep the vehicle. Later, the true owner of car B legally attached it. The plaintiff sued to recover the amount paid to the defendant. Judgment. The contract between the plaintiff and the defendant was void due to a common mistake. Both parties mistakenly assumed the car in question was car A when it was actually car B. Since their agreement was based on an incorrect fundamental assumption, no valid contract existed. 3.8 2 Theories on why common mistake renders a contract void. Implied term theory, most accepted explanation. The contract is implicitly conditional on the truth of a material fact. If the assumption turns out to be incorrect, no valid contract exists. Restitution applies, parties must return what was exchanged. 3.8.3 Common mistake must relate to a term of the contract. For a common mistake to invalidate a contract, the mistaken assumption must be elevated to a term of the contract. Express or tacit agreement that the contract's validity depends on the assumption being correct. If the common mistake relates only to motive, i.e., a mistaken belief influencing the decision to contract, the contract remains valid. In Dickinson Motors, the court held that the mistake must be vital to the transaction, meaning neither party would have agreed to the contract had they known the truth. If the mistake is fundamental, it qualifies as a tacit term, rendering the contract void. Next page. 3.9 Rectification. When parties reduce their agreement to writing, the document may fail to accurately reflect their common intention. No actual mistake, dissensus, occurs since both parties are in full agreement. If parties cannot agree on amending the document, one party may apply to court for rectification to ensure the document correctly reflects their true common intention. The court does not rectify the contract itself, only the written document that misrepresents the intended agreement. 3.9.1 Legal basis for rectification. Rooted in South African contract law's subjective approach, a party can rely on the terms actually agreed upon rather than those erroneously recorded. Rectification is allowed when a bona fide mutual mistake led to an incorrect recording of the agreement. One party fraudulently misrepresented the terms when reducing the contract to writing. The party seeking rectification must prove the document does not reflect the common intention of both parties, the true intention of the parties, how the document should be amended to align with that intention, evidence of a prior agreement, even if not a formal contract, is usually sufficient to establish true intent. 3.9 To case law on rectification. Mouton v. Hanekom. Rectification granted even though the parties intentionally left parts of their agreement unwritten. Court upheld the true intention of the parties, despite the absence of written terms. Milner Street Properties, Proprietary, Limited v. Eckstein Properties, Proprietary, Limited. Agreement was correctly recorded, but parties mistakenly believed it qualified for a 0 rating under VAT laws. Court permitted rectification to align the contract with the relevant statutory amendment. Courts may allow rectification to prevent unfair consequences caused by incorrect recording. 3.9.3 Limitations on rectification. Where writing is a constitutive requirement for a contract, rectification is not permitted if the document fails to comply with prescribed formalities. Example, if a contract requires a written document to be valid, and the document does not meet formal requirements, it cannot be rectified. However, if a document appears to comply with formalities, but contains an error, rectification is possible. Next page, Chapter 4, Improperly Obtained Consensus. 4.1 Introduction. Contracts require true consensus for validity. If consensus is obtained improperly, remedies include restitutio in integrum, restoration of original position, delictual damages for loss suffered, possibility of rescission as a general remedy. 4.1.1 Restitutio in integrum aims to restore parties to their pre-contractual positions. Available where consensus was obtained through misrepresentation, duress, undue influence, or commercial bribery. 4.1 2 Delictual damages, separate from contractual remedies, requires proof of wrongfulness, fault, causation, and harm. 4.1.3 A general ground for rescission. Courts have debated whether improperly obtained consensus should always justify rescission. Some cases allow rescission only where justice demands it. 4.2 Misrepresentation definition: a false statement of fact that induces a party to contract. Misrepresentation renders a contract voidable rather than void. 4.2.1 Misrepresentation distinguished from other pre-contractual misstatements. 4.2.1.1 Warranties or contractual terms. Warranties are binding contractual terms, unlike mere representations. Breach of warranty gives rise to a contractual claim rather than misrepresentation. 4.2.1 Opinions, statements as to the future, and statements of law. Opinions and future statements are not misrepresentations unless made fraudulently. Incorrect statements of law generally do not amount to misrepresentation unless fraudulent. 4.1.3 Puffs, simplex commendatio, exaggerated sales talk is not legally actionable unless it crosses into fraud. 4.1.4 Dicta promise statements that fall between puffs and warranties may give rise to contractual liability if found to have been intended as a term. 4.2.2 Misrepresentation and mistake. If a misrepresentation induces a mistake, it may render the contract voidable. Mistakes caused by misrepresentation differ from innocent unilateral mistakes. 4.2.3 Remedies for misrepresentation. 4.3.1 Rescission and restitution. Rescission allows the innocent party to cancel the contract and seek restoration. 4.2.2 Misrepresentation as a defense. A party may raise misrepresentation as a defense to avoid performance. 4.2.3.3 Damages. Negligent and fraudulent misrepresentation allow for delictual damages. Innocent misrepresentation does not necessarily lead to damages unless there is a contractual term to that effect. 4.2.4 Misrepresentation by silence, non-disclosure. General rule: no duty to disclose unless there is a special duty of disclosure, for example, fiduciary relationship. A half-truth is misleading. There is active concealment. Non-disclosure can amount to fraud in some cases. 4.3 Duress. Definition: when a party is forced into a contract due to unlawful pressure or threats. 4.3.1 The nature of coercion. The pressure must be serious enough to overcome the victim's will. 4.3. 2. The reasonableness of the fear. The threatened harm must be serious enough that a reasonable person would feel compelled to act. 4.3.3 The object of the threat. The threat must be directed at the person or their family, their property or financial interests. 4.3.4 The imminence of the harm. The threat must be imminent and unavoidable. 4.3.5 The unlawfulness of the threat. If the threat is lawful, for example, a lawsuit, it is not duress. If unlawful, the contract is voidable. 4.3.6 Damage. If the victim suffers harm, they may claim delictual damages in addition to rescission. 4.3.7 Duress by a third party. If a third party applies duress, the contract remains binding unless the other party knew or ought to have known. 4.4 Undue influence definition. When one party exerts improper influence over another to secure an unfair contract. 4.4.1 Origins of the doctrine rooted in equity prevents abuse of trust and dependency relationships. 4.4 The requirements. The victim must prove influence was exercised. The influence was undue or excessive. The contract was substantially unfair. 4.4.3 Abuse of circumstances arises when a dominant party exploits a weaker party, for example, lawyer-client, guardian-ward. The stronger party bears the burden of proving the contract was fair. 4.5 Commercial bribery occurs when a third party influences a contracting party through bribes or secret commissions. If proven, the contract may be voidable. 4.6 The road ahead. Further grounds for rescission. Legal scholars debate expanding rescission grounds to cover economic duress, abuse of bargaining power. 4.7 Consumers' right to fair and honest dealing under the Consumer Protection Act, CPA. The CPA protects consumers from improperly obtained consensus. Key provisions. Section 40 prohibits unconscionable conduct, undue influence, and duress. Section 41 prohibits false, misleading, and deceptive representations. Section 48 declares unfair, unreasonable, or unjust contracts void. The CPA grants consumers rights to rescission, refunds, and damages. Next page. 4.1 Introduction. Contracts remain valid even if induced by misrepresentation, duress, or undue influence. Unlike material mistake, there is no lack of consensus, as parties understand the terms and the contracting party. However, the contract is voidable at the option of the innocent party. The innocent party may either rescind, cancel the contract and restore benefits exchanged, enforce the contract, accepting the flawed consensus. Until formally set aside, the contract remains valid and enforceable. 4.1.1 Restitutio in integrum. A remedy allowing a party to rescind, cancel a voidable contract and restore the parties to their original positions. Origin, derived from Roman law, dolus, metus, minority. Modern application, applies to misrepresentation, duress, undue influence, or bribery. No court order required. A party may rescind extrajudicially. However, a court order is advisable when the validity of rescission is disputed. To avoid reliance by third parties, restitutio in integrum is available as both an action to set aside the contract, a defense to resist enforcement. Process and effects of rescission. The innocent party must elect whether to 1. Rescind the contract notifying the other party terminates the contract. 2. Uphold the contract. The party remains bound by its terms. Once made, the election is final and irreversible unless both parties agree otherwise. On rescission, both parties must restore benefits received under the contract. The innocent party must return what they received unless equity or justice dictates otherwise. The other party cannot restore performance. In such cases, the innocent party may claim the value of their performance. The right to rescind may be lost by affirmation, choosing to uphold the contract; waiver, voluntarily giving up the right; prescription, expiration of the legal period to act. 4.1 2 Delictual damages. When a party induces a contract through wrongful means, their conduct may constitute a delict. Delictual damages can be claimed regardless of whether the innocent party rescinds or upholds the contract. Nature of damages. Governed by Actio Legis Aquilae, measured by the negative interest principle places the innocent party in the position they would have been in had the delict not occurred. Covers wasted expenses and consequential losses. Impact of rescission on damages. If the contract is rescinded, damages supplement restitution, ensuring no financial loss remains. If the contract is upheld, damages cover financial losses caused by the wrongful act, for example, overpayment for an item due to misrepresentation. Are these remedies delictual in nature? Restitution and rescission are contractual remedies, distinct from delictual damages. Some scholars, for example, Van Husteen et al., argued that rescission itself is delictual, aligning its elements with delictual liability, conduct, wrongfulness, fault, causation, and an undesirable result. However, courts do not follow this approach. Rescission does not require wrongfulness or fault, unlike delict. Financial loss. Rescission focuses on restoring the status quo. The separation of contract and delict principles remains essential in legal reasoning. Next. Page 4.1.3 A general ground for rescission. Originally, rescission was available for fraud, dolus, duress, metus. Modern law has expanded the grounds to include non-fraudulent misrepresentation, extension of fraud, undue influence, distinct from duress, commercial bribery of an agent, a new, independent ground. Key issue: is there a closed list, numerous clauses, of grounds for rescission? Common factor among all grounds: consent obtained through illegitimate means. Legal principle: no one should be bound by a contract where their consent was improperly obtained. Future developments: new grounds may emerge either as distinct defenses, for example, commercial bribery, or as extensions of existing ones, for example, economic duress, abuse of circumstances. However, courts are unlikely to merge all grounds into a single general ground for rescission, as each defense has distinct elements. 4.2 Misrepresentation. Definition: a false statement of past or present fact, made before or at the time of contracting, relating to the contract. Forms: express verbal statement, implied by conduct, for example, concealing defects in a product. Silence may constitute misrepresentation, if there is a duty to disclose. Types of misrepresentation: fraudulent misrepresentation, made knowingly, or without belief in its truth, or recklessly indifferent to its truth. Test: subjective honest belief. If belief is dishonest, even if actually held, it is fraudulent. Negligent misrepresentation, made honestly but with carelessness. Innocent misrepresentation, made without fraud or negligence. Previously, all non-fraudulent misrepresentations were deemed innocent, but modern law distinguishes negligent from truly innocent misrepresentation. 4.2.1 Misrepresentation distinguished from other pre-contractual misstatements. Importance: the type of misstatement determines available remedies. If categories overlap, the misled party may choose their remedy. Misrepresentation must be distinguished from warranties or contractual terms, enforceable promises, not just statements. Opinions, future statements, and statements of law generally not actionable unless fraudulent. Puffs, simplex commendatio, mere sales talk, not legally binding. Dicta et promissa, statements made during negotiations that may influence interpretation, but are not enforceable promises. Next. Page 4.1.1 Warranties or contractual terms. Key distinction: representation, a statement made during negotiations, not binding unless the law imposes liability. Warranty, a contractual term, meaning the party is bound to its truth. Test for warranty: did the parties intend for the statement to form part of the contract? Objective factors: importance of the statement to the transaction, Timing of the statement, closer to contract formation equals more likely to be a term. Response to a specific query from the representee. Estopel and Smith v. Hughes principle. Even without actual intention to contract, a party may be bound if their actions led the other party to reasonably believe the statement was warranted. Legal consequences of breach. Breach of warranty equals breach of contract remedies, cancellation if material, damages for lost expected benefits. Overlap with misrepresentation. If a misrepresentation is later incorporated into the contract, the representee may sue either for misrepresentation or breach of contract. _4. 1.2 Opinions, statements as to the future and statements of law. General rule. Opinions, future intentions, and statements of law are not actionable misrepresentations. Exception. Misrepresentation of one's own state of mind. If a party does not actually hold the opinion or intention they express, this is actionable. Case law. English Court of Appeal ruled that, in exceptional cases, an opinion may imply a representation that there are reasonable grounds for holding it. Statements of law. Traditionally seen as opinion, not fact, but if the speaker does not actually hold the legal opinion, it may be misrepresentation. If the speaker impliedly represents having reasonable grounds for the legal view, liability may arise. Difficult distinction. General legal statements equals opinion. Statements applying law to a contract equals may be binding if they induce reliance. _4. 1.3 Puffs, simplex commendatio, definition, mere exaggerated praise that does not create legal liability. Classic examples. A desirable residence for a family of distinction. Well-built house. Liability arises if the statement includes specific details that imply factual accuracy. The exaggeration is mixed with factual claims. The statement is objectively misleading. Underlying principle. Reliance on puffery is not reasonable. _4. 1.4 Dicta et promissa. Definition. A material statement made by the seller to the buyer during negotiations, relating to the quality of the item sold, and going beyond mere puffery. Key features. Limited to contracts of sale. Distinct from general misrepresentation, but may overlap. Remedies, Roman Dutch law. Actio retributoria cancel the contract. Actio quanti minoris seek a price reduction. If guaranteed by the seller becomes a warranty, leading to breach of contract remedies. Choice of remedies. Purchaser can sue under misrepresentation, breach of warranty, or edilition remedies. Next. Page 4. 2 Misrepresentation and mistake. Relationship. All actionable misrepresentations induce a form of mistake, as the representee must be misled. However, not all misrepresentations raise the legal doctrine of mistake. Key distinction. Misrepresentation induces a mistaken motive, meaning it does not nullify the contract ab initio, from the outset. Instead, the contract is voidable at the instance of the representee. Mistake. If the mistake is material and meets the use error test, justifiable error, the contract is void ab initio for lack of consensus. Impact of exclusion clauses. General rule. A contractual clause stating that no misrepresentation has been made can exclude liability unless fraud is involved. Exception. If the misrepresentation induces a material mistake, the contract is void, rendering the exclusion clause ineffective. Failure to disclose an exclusion clause, where there is a duty to do so, may itself be a misrepresentation by silence, making the resulting mistake use. Diagram 4.2 illustrates. A misrepresentation by A induces B to enter a contract. The contract contains an exclusion clause attempting to prevent B from relying on misrepresentation. If B's error is use, the contract is void, and the exclusion clause has no legal effect. Next. Page 4. 2 Remedies for misrepresentation. A party misled by misrepresentation may rescind the contract and claim restitution, restitutio in integrum. Use misrepresentation as a defense when sued on the contract. Claim damages for losses caused by the misrepresentation. _4.2.1 Rescission and restitution. A party can seek rescission and restitution if the following 4 factors are present. 1. Misrepresentation by the other party. The misrepresentation must come from the other contracting party or someone for whom they are responsible. If made by an independent third party, it does not affect the contract's validity unless it induces a material mistake, which may void the contract. The misled party may still claim damages against a third party if their conduct constitutes a delict. 2. Inducement. The misrepresentation must have caused the representee to enter into the contract. No relief is granted if the representee knew the statement was false. The statement failed to reach the representee. The statement did not influence the representee judgment. Misrepresentation need not be the sole or dominant cause, but must be one of the inducing factors. Test for inducement. Subjective. Did the misrepresentation actually induce the representee to enter the contract? The effect on a reasonable person is a relevant consideration, but not the decisive test. Distinction between types of fraud. Dans locum contractui. If the contract would not have been concluded but for the fraud, rescission is allowed. Incidens in contractum. If the contract would have been concluded anyway, but on different terms, rescission is not allowed. Only damages may be claimed. This distinction may also apply to non-fraudulent misrepresentation, referred to as causal versus incidental misrepresentation. 3. Intention to induce. Misrepresentation must be made with the intention to induce the other party to enter into the contract. This does not require an intention to deceive, which is necessary for fraud. If no intention to induce exists or the representation was made to a third party and later acted upon by the contract's representee, reliance may be unreasonable. Exception: if the unreasonable reliance was foreseeable, rescission may still be granted. 4. Materiality. The misrepresentation must be material to justify rescission. Definitions of materiality. The misrepresentation must be likely to induce a reasonable person to enter into the contract. Some courts equate materiality with causation. If it actually induced the contract, it is material. Competing views on materiality. If only causal misrepresentations allow rescission, dans type, materiality is part of inducement. If incidental misrepresentations, incidents, allow rescission, materiality must be a separate requirement to prevent rescission for trivial misrepresentations. Alternative view: materiality exists if the statement was intended to be acted upon by the representee. A reasonable person in the representee position would have been induced. Fault not required. Rescission is allowed regardless of fault, whether the misrepresentation was fraudulent, negligent, or innocent. Historical development. Roman and Roman Dutch law only allowed rescission for fraudulent misrepresentation. English law later allowed rescission for innocent misrepresentation on equitable grounds. South African courts followed suit, first allowing an innocent misrepresentation as a defense, Vayun v. Hillier. Later, the right to set aside a contract based on innocent misrepresentation became firmly established. Next page. 4.2.3. Misrepresentation as a defense. Misrepresentation can serve as a defense to an action on a contract, allowing a representee to resist enforcement. Pleading misrepresentation as a defense is a form of rescission, requiring proof of the same facts necessary for rescission. A misrepresentation may prevent specific performance even if it does not justify rescission. 4.2.3.3 Damages. A representee may recover damages for patrimonial loss caused by the misrepresentation. The state of mind of the representer, fraudulent, negligent, or innocent misrepresentation, determines the liability. Fraudulent misrepresentation. Fraudulent misrepresentation is a delict, similar to the English tort of deceit, actionable under the Actio Legis Aquilae. 5 essential elements of fraudulent misrepresentation. 1. A representation. 2. Knowledge that the representation is false. 3. Intention for the representee to act upon it. 4. The representee acted upon the misrepresentation. 5. The representee suffered damage as a result. Legal principles related to fraudulent misrepresentation. The representer's motive is irrelevant, intent to deceive suffices. Recklessness as to whether the representee would act on the misrepresentation satisfies intent. The representee does not need to prove that a reasonable person would have been deceived. Fraud exclusion clauses are unenforceable as contrary to public policy. Measure of damages. Fraud is a delict, so delictual rather than contractual damages apply. Trotman v. Edwick. Contractual damages restore the benefit of the bargain. Delictual damages restore the patrimonial position before the wrongful act. The representee is restored to the financial position they would have been in had the misrepresentation not been made. Key distinctions. Delictual damages do not make good the representation, as in breach of warranty cases. Application of damages varies based on whether the contract is upheld or rescinded. Consequential losses from fraud. Recoverable if not too remote. Example, if misrepresentation led to the purchase of an infected animal, resulting in a reduction in herd value, the reduction is recoverable. Rescission versus upholding the contract. If rescinded, restitution eliminates transaction loss, limiting damages to wasted costs. If upheld, the representee may suffer intrinsic loss requiring separate assessment. $stands versus $incidents. $stands inducing contract formation. But for the fraud, the contract would not have been concluded. The representee is compensated as if rescission and restitution occurred. The measure, value of performance given less benefits received. Example, if a buyer paid more than the actual worth, damages equal the overpayment. Incidents, influencing contract terms. The contract would have been concluded regardless, but on different terms. The representee loss is the difference between the price paid and the price they would have paid absent the misrepresentation. Example, bad bargainer, loss equals actual price paid, price that would have been paid. Good bargainer, damages may include lost profit, lucrum cessans. Swings and roundabouts principle. In $stands, if the representee benefits from the contract overall, no damages are awarded. In $incidents, loss of profit due to fraud is recoverable even if the representee gained from the transaction. Burden of proof in $incidents cases. The representee must show what they would have paid, but for the misrepresentation. If this price is below market value, the representee must prove the representer would have accepted it. Courts assume the price paid reflects the value of the mercs in its represented condition unless proven otherwise. If no counter-evidence exists, damages equals price paid, actual value. Next page. Judicial application of misrepresentation principles. While courts support the principles distinguishing delictual and contractual damages, their application is inconsistent. Courts have been criticized for awarding contractual damages under the guise of delictual damages. It is not enough to argue that in some cases, the two measures yield the same result. Courts must still apply the correct legal principle. Judicial inconsistencies. Tendency to award contractual damages in delictual cases. Even when using a different method of assessment, courts may inadvertently apply contractual principles. Example, in Ranger, the court held that when an item is misrepresented as free from defects, damages may be assessed as the cost of removing the defect. This approach effectively makes the representation good, which is a contractual remedy rather than a delictual one. Criticism of this approach. The delictual measure should focus on placing the representee in their pre-contractual position, rather than ensuring they receive what was represented. Awarding repair costs or the cost of making the representation true effectively enforces the misrepresented promise, which aligns with contract law. Conclusion. Courts recognize the distinction between delictual and contractual damages, but sometimes blur the lines in practice. The approach in Ranger reflects a practical but legally flawed method, favoring a contractual measure of damages. Judicial decisions should ensure a clear application of delictual principles to uphold the correct legal framework. Next page. Negligent misrepresentation. Recognition of delictual liability. Before Bayer South Africa, Proprietary, Limited v. Frost, uncertainty remained regarding whether delictual damages could be awarded for negligent misrepresentation inducing a contract. This issue was part of a broader debate on whether negligent misstatements causing pure economic loss, as opposed to physical damage, should be actionable in delict. Historically, courts were reluctant to award damages for negligent misstatements due to concerns about indeterminate liability, Ultramar's principle. Derry v. Peake, House of Lords, was widely interpreted as excluding tortious liability for negligent misstatements. Shift in legal approach. The English courts altered their stance in Hedley Byrne and Co. Limited v. Heller and Partners Limited, recognizing liability for negligent misstatements causing economic loss. South African courts followed in Administrateur, Natal v. Trust Bank van Africa BPK, confirming that negligent misstatements can be actionable in delict, subject to satisfying the Aquilian liability requirements. Judicial uncertainty in South Africa. In Hammond v. Moolman, the Appellate Division cast doubt on whether a negligent misrepresentation inducing a contract should give rise to delictual liability. Court's reasoning. Contracting parties should take precautions, such as requiring guarantees for representations. Existing contractual remedies, rescission, price reduction, were deemed adequate. Recognizing delictual liability could create more problems than it solves. These obiter dicta were widely criticized. Rescission or price reduction does not compensate for consequential loss. Expecting parties to guarantee every statement is impractical and undermines good faith in business. Mere puffs are immune, but careless misstatements should not be freely allowed. Judicial shift towards liability. Post-Trust Bank, some provincial courts departed from Hammond, recognizing delictual liability for negligent misrepresentation inducing a contract. The English Court of Appeal also extended Hedley Byrne principles to pre-contractual misrepresentation. Final recognition in Bayer South Africa, Proprietary, Limited v. Frost. The Appellate Division confirmed that negligent misrepresentation inducing a contract can give rise to delictual liability. Requirements. Must satisfy all elements of Aquilian liability: conduct, wrongfulness, fault, causation, damage. Wrongfulness and causation play a key role in limiting scope and preventing excessive liability. Measure of damages. Since the cause of action is delictual, damages for negligent misrepresentation follow the same measure as fraudulent misrepresentation. The representee is placed in the position they would have occupied had the misrepresentation not been made. Not entitled to the contractual measure, i.e., making the representation true. Next page. Innocent misrepresentation. General rule: no damages for innocent misrepresentation. Since an innocent misrepresentation is not a term of the contract and is made without intent, dolus, or negligence, culpa, contractual damages are unavailable, no breach of contract. Delictual damages are unavailable, no fault required for Aquilian liability. Consequential losses suffered due to reliance on an innocent misrepresentation are not compensable. Potential for restitutional damages. The question remains whether a party induced to contract by an innocent misrepresentation can affirm the contract and claim restitutional damages, rather than rescinding it. Various terms have been used for this concept. Restitutional damages. Partial restitution. Reduction of performance. Quanti minoris type damages. Actio quanti minoris, edilition remedy for sale contracts. In contracts of sale, the actio quanti minoris allows a buyer to seek a reduction in price for defects in the merks, the subject of the contract. This remedy is available even for innocent misrepresentation, if the statement qualifies as a dictum et promissum, a positive assertion about the quality of the goods. However, outside the edilition context, the availability of restitutional damages is uncertain. Conflicting judicial views. Many judicial dicta deny any damages for innocent misrepresentation. However, in Brink v. Robinson, Marstorp CJ took the opposite view. A representee should not suffer damages simply because the misrepresentation was innocent. The problem with such dicta is the failure to distinguish between compensatory and restitutional damages. Compensatory damages, for loss suffered, are not available. Restitutional damages, restoring economic balance, may be justified. Comparative perspective, English law. Under S22 of the Misrepresentation Act 1967, English courts may award restitutional damages in lieu of rescission for innocent misrepresentation. South African scholars have called for similar relief, but finding a doctrinal basis is challenging. Unjustified enrichment. No, because the sine causa, lack of legal justification, requirement is not met. Strict delictual liability. No, because misrepresentation is not an inherently hazardous activity. Equitable justifications for restitutional damages. The best argument for restitutional damages is an equitable extension of the right to rescission. If courts allow rescission due to innocent misrepresentation, why not also allow partial restitution? Forcing the representee to rescind the contract to obtain relief may be disproportionate. The representer retains a benefit obtained through misrepresentation, which disturbs economic balance. Key case, Fame, Proprietary, Limited v. Pazes. The appellate division held that a purchaser induced to contract by an unfounded dictum et promissum may 1. Cancel the contract, actio requisitoria. 2. Claim a reduction in price, actio quanti minoris. Since a dictum et promissum is a form of innocent misrepresentation, this effectively allows a remedy akin to damages. Limitations of the actio quanti minoris. Only applies to contracts of sale, or possibly exchange. Only applies to misrepresentations about the quality of the goods. Does not allow recovery of consequential damages, unless the seller is a manufacturer, or a merchant seller professing expertise. The measure of price reduction is difference between the price paid and the actual value of the goods, not the difference between the agreed price and the price the buyer would have paid but for the misstatement. In some cases, alleging an innocent dictum et promissum may be more beneficial than alleging fraud, an odd result. Conclusion, towards a general remedy for restitutional damages. The actio quanti minoris shows courts are willing to grant relief for innocent misrepresentation in certain contexts. The question remains, why should relief be limited to sale contracts? Courts in Fame were influenced by equitable considerations when extending edilition remedies. A general right to restitutional damages for innocent misrepresentation remains uncertain but arguable on equitable grounds. Next page. Misrepresentation by silence, non-disclosure. General rule and legal duty. A failure to disclose a material fact, when under a legal duty to do so, constitutes misrepresentation by silence, comissio per omissionem. A party induced to contract by unlawful non-disclosure is entitled to the same remedies as victims of other misrepresentations. The key issue is establishing whether the failure to disclose was unlawful, wrongful. Reluctance to impose liability for omissions. General rule: silence is prima facie lawful. Contracting parties are not generally required to disclose all material information to the other party. However, exceptions exist where a duty to disclose is legally imposed. Exceptions: when a duty to disclose arises. 1. Contracts of insurance, agency, partnership, or engagement. These contracts are traditionally described as uberrimi fidei, utmost good faith. For example, an insurance applicant must disclose facts affecting the risk, whether asked or not. 2. Fiduciary relationships. For example, attorney-client, guardian-ward, overlaps with uberrimi fidei contracts. 3. Statutory duty. For example, Companies Act requires disclosure in a prospectus for share subscriptions. 4. Seller's knowledge of a latent defect. Under the edilition edict, the seller is liable even if unaware of the defect. If aware and deliberately silent, liability is expanded, fraud. 5. Unrehabilitated insolvent applying for credit. Status must be disclosed. 6. Prior conduct or statements making silence misleading. Situations where prior actions or words create a misleading impression. Conduct concealing otherwise apparent facts. Prior representation leads the other party not to expect a specific contract clause. Silence distorts a positive statement, for example, a literally true but misleading statement. Legal basis of the duty to disclose. The duty arises ex lege, by operation of law, not from an implied contract term. Courts have developed a general test for liability based on prior case law. General test for liability. Courts impose a duty to disclose where the information is within one party's exclusive knowledge. The other party relies involuntarily on the first party's disclosure. Honest businesspersons would mutually recognize a duty to disclose. Milner's formulation of the duty. A duty to disclose arises when one party involuntarily relies on the frank disclosure of certain facts within the exclusive knowledge of the other. Honest individuals in the circumstances would recognize the right to be informed. Conversely, no duty exists when facts are equally observable. Information is ascertainable with ordinary diligence. Both parties have equal access to the facts. Application of the test. The Supreme Court of Appeal has adopted Milner's test. It aligns with the principle of good faith in contracts. Uberi fidei contracts attract disclosure duties due to their inherent reliance and trust. In other contracts, the duty depends on case-specific factors. Flexibility of the test. The test is inherently vague, much like the test for wrongfulness in delict. Courts assess whether non-disclosure is merely unethical or legally wrongful. Meskin v. Anglo-American Corporation confirmed that both tests rely on societal norms, the mores of today. Disclosure of facts affecting the value of the subject matter. A purchaser is generally not required to disclose facts increasing the value of the mercs. However, there is no absolute rule. Each case depends on its circumstances. If a seller could not reasonably ascertain the true facts, non-disclosure might be wrongful. Non-fraudulent unlawful non-disclosure. Unlawful non-disclosure does not always require fraud. An innocent or negligent failure to disclose can still be unlawful in certain situations. Next page. Duress, metus. Definition and effect. Duress, metus, is improper pressure amounting to intimidation. A party consents to a contract under duress due to fear from an illegitimate threat, not through free will. In rare cases of extreme fear, consensus may be entirely excluded. A contract induced by duress remains valid, as forced consent, voluntas character est tamen voluntas, is still legally effective. However, such a contract is voidable at the option of the coerced party. Remedies available. The coerced party may set aside the contract, claim restitution, resist enforcement by the other party. In a proper case, claim damages, as duress is a delict giving rise to an Aquilian action. Requirements for duress. The threat must be 1. Unlawful. 2. An effective cause of the contract, but for the threat, the party would not have contracted, or would have done so on different terms. Wessel's formulation of duress elements. Wessel's, 1930s, outlined 5 elements for proving duress. 1. Actual violence or reasonable fear. 2. Threat of considerable evil to the party or their family. 3. Threat of imminent or inevitable harm. 4. Threat must be contra bonos mores, against public policy. 5. Moral pressure must have caused damage. Criticism of Wessel's formulation. Confirmed in Brudrick v. Smutsno and followed in later cases. Considered unsatisfactory and some elements questionable. Few cases have scrutinized these elements in detail. Academic commentators propose reformulating the test to align with modern legal thought. 4.3. 1. The nature of coercion. Coercion in duress is mental, not physical, involves vis compulsiva, psychological pressure, not vis absoluta, physical force. Vis absoluta equals absolute force, for example, forcing someone's hand to sign a document, rendering no contract. Vis compulsiva equals pressure on the victim's will, forcing a choice between two evils. Entering the contract. Suffering harm. Even if violence is involved, the coercion results from the threat of continued violence, not the violence itself. 4.3. To the reasonableness of fear. Some authorities argue that fear must be grave enough to influence a reasonable person. Others suggest personal attributes, for example, age, sex, should be considered. Grotius' view, preferred approach. Fear need not be reasonable. Prevents exploitation of unreasonable fears. The test should focus on whether the threat induced the contract, not whether the fear was reasonable. Unreasonable fear makes proving duress harder, but this is an issue of evidence, not legal principle. Next page. 4.3 Duress metis continued. 4.3 The object of the threat. Traditionally, the threat must target life, bodily integrity, or property of the person or their immediate family. Grotius extends this to threats against one's honor. Courts may not strictly limit relief to immediate family, as threats against distant relatives or even strangers could still constitute duress. Duress of goods, threats to property. Courts require an unequivocal protest at the time of payment or contract entry to prove lack of free consent. Hendricks v. Barnett clarified that this is a matter of proof, not an essential element of duress. Silence does not necessarily indicate voluntary consent. Economic duress. Unclear whether South African law recognizes it. English and American law accept economic duress. The Supreme Court of Appeal acknowledged its potential recognition in South Africa but emphasized economic harm is generally lawful in a competitive economy. Hard bargaining is not duress. 4.3. For the imminence of the harm. Wessel states the threat must be of an imminent or inevitable evil, based on Roman law. The rationale, the victim should seek legal protection rather than yield. Voot and Van Leven suggest this requirement is not absolute. Modern approach, relief should be granted even if the harm was not imminent or inevitable, provided the victim had no reasonable or acceptable alternatives to avoid the harm. 4.3.5 The unlawfulness of the threat. The threat must be unlawful or contra bonos mores. Fear alone does not suffice. The contract must result from improper means. A threat is unlawful if the threatened action is itself unlawful, for example, murder, assault. The threat is made for an illegitimate purpose. Lawful threats. Threatening civil action is not unlawful unless in exceptional cases. A settlement reached to avoid civil action is not voidable for duress. Threats of criminal prosecution. Unlawful if used to extort a benefit to which the creditor is not entitled. Disputed whether it is lawful if the debtor is actually guilty. Transvaal and Natal cases, not unlawful if the debtor is guilty. Cape cases and academic opinion, using criminal prosecution for private enforcement, is against public interest and likely void for illegality. 4.3.6 Damage. Aquilian damages require financial loss. Some cases suggest damage is necessary even for restitutio in integrum, following Voot and Wessel's unclear justification, as restitutio in integrum is based on improperly obtained consensus, not harm. Brudrick v. Smuts interpretation. The victim must prove they incurred obligations they would not otherwise have accepted. The contract itself satisfies the damage requirement. 4.3.7 Duress by a third party. If duress originates from an outsider, acting independently and without the other contracting party's knowledge, normally, the victim could only sue the third party for damages. Historical approach, courts allowed restitutio in integrum even in such cases. Modern expectation, Courts will likely reject this except where public policy demands voidability, for example, marriage contracts. Next. Page 4.3 Duress, Threats and Improper Pressure in Contracts 4.3.3 The object of the threat. Threat must be directed at life, bodily integrity, or property of the person or their immediate family. Grotius suggested threats to one's honor as sufficient, but this view is not widely accepted. Courts are unlikely to deny relief if threats involve distant relatives or strangers, especially in cases of physical violence. Duress of goods. Courts require unequivocal protest at the time of payment or contract formation to prove involuntary consent. Hendricks v. Barnett, distinction between duress of goods and personal duress relates to proof, not legal principles. Silence does not necessarily indicate free consent. Relief may be granted if duress is proven. Economic duress. English and American law recognize economic duress in certain cases. South African Supreme Court of Appeal acknowledged economic duress in principle but stated such cases are rare. Hard bargaining is not considered duress unless unlawful economic pressure is applied. 4.3.4 The imminence of the harm. Roman law suggests threats should be of imminent or inevitable evil to justify legal protection. Some writers, Voet, Van Leeuwen, argue this requirement is unnecessary. Courts should grant relief even if harm is not imminent, provided the party had no reasonable alternative but to succumb to the threat. 4.3.5 The unlawfulness of the threat. Threat must be unlawful or contra bonos mores. Lawful threats, for example, enforcing a legal right through a civil action, do not amount to duress. Threat of criminal prosecution. If used to extort an undue benefit or the accused is innocent, it is unlawful. If the accused is guilty and the creditor seeks only what is due, legality is debated. Some Transvaal and Natal cases uphold such threats as lawful. Cape courts and some academics oppose this view, arguing it is against public interest. 4.3.6 Damage. Financial loss is essential for Aquilian damages, but some cases suggest damage is also required for restitutio in integrum. Brudrick v. Smuts, duress claim requires proof that the victim incurred obligations they would not have otherwise undertaken. 4.3.7 Duress by a third party. Common law rule: if duress is from a third party without the other contracting party's knowledge, only a damages claim is available. However, older authorities allowed restitutio in integrum. The courts may invalidate contracts in special cases, for example, marriages affected by duress. 4.4 Undue influence. More subtle than duress, erodes independent judgment rather than using threats or intimidation. Common in fiduciary relationships, for example, doctor-patient, attorney-client, parent-child, religious leader-disciple, involves misuse of a position of trust to manipulate another into an agreement. 4.4.1 Origins of the doctrine. Not part of early Roman Dutch law, derived from English law due to limitations in the common law concept of duress. Recognized in Prella v. Jordan as part of South African law, Patel v. Grobelaar confirmed undue influence as a valid ground for rescinding contracts. 4.4 Two requirements, Prella v. Jordan, Patel Case 1. Influence was exerted over the victim. 2. Influence weakened resistance and made the victim compliant. 3. Influence was used unscrupulously to induce a prejudicial contract the victim would not have entered otherwise. Prejudice requirement debated. Some argue mere inducement to contract should suffice. Burden of proof. Unlike English law, where certain relationships create a presumption of undue influence, South African law requires proof of undue influence. Third-party influence. The contract can only be set aside if the other party knew about the undue influence. Damages not yet established if damages can be claimed, but likely available under Aquilian liability. 4.4.3 Abuse of circumstances. Similar to undue influence but occurs in emergency situations where one party exploits the other's desperate circumstances. Blackburn v. Mitchell, a tugboat captain charged an excessive fee to rescue a stranded ship. The contract was invalidated. Unclear in South African law, some argue the contract is enforceable but should be adjusted to a reasonable sum. Van Houstein's proposal treat abuse of circumstances as a distinct consensual defect, but courts have not adopted this view. 4.5 Commercial bribery. Plaaslyk Boredienst, Edens BPK v Keenfos BPK, bribery in contracts is not fraud, as in English law, but a wrongful and immoral means of securing an agreement. Exdal Industrial, Proprietary, Limited v Crown Mills, Proprietary, Limited confirmed commercial bribery, as a distinct ground for contract rescission. Elements of commercial bribery, Exdal Case 1. A reward. 2. Paid or promised. 3. By the briber. 4. To an agent, who can be a go-between. 5. Who can influence. 6. A principal. 7. With the intention. 8. That the agent. 9. Induces the principal, without their knowledge. 10. For the briber's benefit. 11. To enter, maintain, or alter a contract. 12. With the briber or their associate. 4.6 Future grounds for rescission. Legal trend, expanding grounds for rescinding contracts based on improperly obtained consent. Potential future developments. Economic duress, more recognition expected. Abuse of circumstances, may develop as a distinct doctrine. The resurgence of good faith in contract law suggests continued expansion of rescission grounds. 4.7 Consumer Protection Act, CPA, and fair dealing. CPA overlaps with common law on improperly obtained consent. Section 40 prohibits physical force, coercion, undue influence, duress, harassment, and unfair tactics in consumer transactions. Exploiting consumers who cannot protect their interests due to disability, illiteracy, or ignorance. Section 41 prohibits misrepresentation and non-disclosure. CPA versus common law. CPA extends beyond common law by allowing contracts to be challenged for harassment or unfair tactics. Provides additional remedies through consumer protection institutions, for example, ombuds, consumer courts, National Consumer Commission. Compliance notices can be issued against businesses engaging in unfair practices. Failure to comply may result in fines or criminal prosecution. Key takeaways. Duress requires unlawful threat, which must leave the victim with no reasonable alternative. Undue influence involves subtle manipulation in trusted relationships. Abuse of circumstances concerns exploitation of emergencies to secure unfair contracts. Commercial bribery, a distinct ground for contract rescission. Consumer Protection Act expands common law protections and introduces stronger consumer remedies.